Come to order. The clerk will call the roll.
Mr. Chair, you have a quorum?
Okay, and some others will be coming here in just a few minutes. I want to make people understand that today is the last day for revenue bills that have to go to finance. So we're going to try to get those done today. So the first person that's signed up is Senator Reeves. Is he here? Okay. Senator Reeves, you have two bills.
Thank you, Mr. Chairman. I think we Senate Bill 1184, and I think there's an amendment in the nature of a substitute.
This has to do with hate crimes. Senate Bill 1184. Got a substitute. Okay, so what is Senate Bill, the substitute? Second, all in favor of adopting the substitute, say aye. Aye. All opposed, no. The substitute before us. Explain the substitute, Senator Reeves.
Thank you, Mr. Chairman, members of the committee. What it does is try to make the definition of anti-Semitism a little bit easier to understand. What it does is it strikes the word anti-Semitism, puts in the word ethnic. So it's a broader term, and it actually aligns our code section with the Title VI Federal Rights Act that all the presidents in the last few administrations, regardless of party, have laid out what that is. Mr. Chairman, this is just to simply add ethnic or national origin to try to take away some of the confusion that comes along with anti-Semitism and how to define that. It would make it easier for, I think, law enforcement. As a law enforcement officer, it's a lot easier for myself and probably some of my colleagues that have to deal with hate crimes to be able to understand that. And, Mr. Chairman, it's a pretty simple bill. That's the bill.
Mr. Chairman.
Yeah, Senator Serval.
Senator, first of all, you keep talking about this bill changing the definition of anti-Semitism or clarifying the definition. There's no definition of anti-Semitism in this bill. What we're talking about doing is broadening hate crimes to pick up ethnic issues, correct?
Mr. Chairman, Senator Serval, correct.
Mr. Chairman, further question?
Go ahead, Senator Serval.
Senator, we already killed a bill to define anti-Semitism. And I want to make clear that's not what we're doing with this. And can you assure me that as this bill goes through the process, it's not going to come back to us either from the other chamber or from the person up on the third floor with a definition attached to it? And if that's proposed, that you'll resist that?
Mr. Chairman, Senator Serval, sure, but the House is run by someone else who's your friend.
Okay, thank you.
I have a question on line 73. It says or ethnic or national origin. How many ors do we need there? Is the first or appropriate?
Mr. Chairman, I would seek counsel if they want to strike or. I don't know that it makes a difference.
Shouldn't we strike the first or?
Mr. Chair, I don't think it's necessary to strike the first or because we're talking about ethnic or national origin. I'm not sure it makes.
Okay, I see what you mean. All right.
Mr. Chair.
Senator Morsi, did you have a question?
Senator, the last bill that came up before caused some division within the Jewish community. Has the Federation, either the Richmond Federation or Northern Virginia Federation, now agreed with this bill, your substitute?
Mr. Chairman, I took several phone calls on Sunday from a lot of folks, and I think there's a by and large consensus on this bill.
Okay.
Mr. Chair.
Yeah, any other questions?
Mr. Chair.
Yeah, Senator Peterson.
I think I have a motion.
Okay, make a motion.
I move we report this. I think this kind of threads the needle, to be frank, and so I think I would move to report the
Is there a
bill.
second? Any discussion? All in favor? Anybody here want to speak? All in favor of the motion? Is there somebody want to speak on the bill?
If anyone on Zoom would like to speak on this bill, please raise your hand electronically.
Yeah, come on up real quickly. Yeah, coming up. What's your name? The bill's in good shape, we think.
My name is Nancy Ween. I want everyone to look at, I'm changing my testimony, I want everyone to look at section 8.01-42.1. They have removed anti-Semitism in many places, but they have not removed it from 8.01-42.1 in what I have. Please check that section. Well, then this is,
Ma'am, I think you're looking at
Yeah,
old.
okay, have they removed
I think-
anti-Semitism entirely?
They have.
It's not in here.
No, the bill's in good shape. Okay.
Okay.
Is anybody else would
Well,
like
on
to,
my copy, it wasn't.
anybody else would like to say anything? If not, ready to vote?
We have several speakers on Zoom,
I
Mr.
understand.
Chairman.
Go ahead, quickly.
Catherine, you may unmute and speak, and Zaina, you will go next.
I was just going to say what Nancy was going to say, that
okay.
anti-Semitism does not need to be included.
It's not there. It's not there. Okay, anybody else need to speak? All right, the bill has been.
Yes, I actually would like to speak. I was called to speak next, but I just want to emphasize that why was there a question to the Jewish Federation if anti-Semitism, if it was agreed? I just, again,
I don't know.
because the way this has gone down, I just want to make sure that, why was the Jewish Federation asked if they approve? If anti-Semitism
I don't know. Okay, anybody else want to speak? The motion has been made and seconded to report and re-refer the bill to finance. All in favor of the motion, vote aye. All opposed, no.
Ayes 15, no zero.
The bill is reported and re-referred to finance on a vote of 15-0. All right, Senator Reeves, Senator Bill 1188, weapons of terrorism.
Thank you, Mr. Chairman. 1188, what it's going to do is define fentanyl as a weapon of terror. And, Mr. Chairman,
Go ahead.
I wasn't going to talk about this because it's kind of personal, but most of you know I did time as an undercover narc, dealt with a lot of drugs, but I've never dealt with anything like fentanyl. And I want to tell a personal story real quick. This has affected more families than you'll ever imagine. It's affected my family. My daughter's fiance died of fentanyl overdose. And until we start going after the manufacturers and these guys that are distributing this thing, not the low-level guys, and not the users, but the real entities, where it's coming from China and from the cartels, we're not going to make a difference. And it's going to keep killing our kids. And it doesn't take very much, and everybody knows that. And so until we take a bold step and start going after these folks, we're going to keep having our kids die. So that's why I put the bill in. I'm tired of seeing people die.
Okay. Anybody have any questions? Anybody want to speak
Mr.
on
Chair.
the bill?
Mr. Chair.
Yeah, Senator Boysko.
Thank you, Mr. Chair. Senator Reeves, Mr. Chairman, Senator Reeves, I'm have a lot of horror. I mean, it's horrible to hear that you've personally been affected. You just said that you didn't feel that you were going to go against the local sellers and users. How does this not affect them the way I'm reading that it
Madam Chair, Senator Boyska, if you look at Section D, there's one word that maybe I'm not comfortable with, and maybe some of the defense attorneys might not be either. It says any person who sells, gives, distributes, or manufactures. I think a lot of time users give stuff away, and that one word, as somebody who understands the process of addiction, kind of bothers me. But I think if you sell it, or you distribute it, or manufacture it, I think that's a different level.
Yeah, Senator Morsi, got any question?
Are you finished? Did you have?
Senator Morsi?
I'm going to defer to my seatmate if she
Thank
had
you,
a
Mr.
follow-up
Chair. Yeah,
question, then I do
follow-up.
have a
Yeah,
question.
Senator Boysko.
Mr. Chair, Senator, I've spoken on this a few times. I serve on the Council for Substance Abuse Recovery, and one of the things that is very clear is that people who are using are not thinking like you and I are. They
Correct.
do not, they're doing whatever they have to do because their brains are not fully
Been
functioning.
rewired. Yes, ma'am.
And for us to criminalize people who are at the local level selling and giving and distributing, I have some heartburn over that. While I agree that we need to address this, so if you were talking about the high-level manufacturers, that might be I might be able to, but I cannot support. And I'm wondering how you feel about that. We've already dealt with several bills similar to this.
Mr. Chair.
Yeah, Senator
Senator
Reeves.
Boysko, the only way that you can actually probably define each of those terms, is it distribution if I sell you a small piece? You would have to go into the code section and start identifying it by weight, which we've done for a lot of Schedule II and Schedule I narcotics. So, but fentanyl in and of itself is so potent, that an accommodation of giving somebody, I personally feel like if you know what it is and you're selling it and you're distributing it, then you're making a moral decision knowing that the actions of the results of the actions that you are taking to make money. So distribute and sell means you're trying to make money off of it. If you give somebody something, you're not asking for anything in return. But if you are selling it, then you are intent on making money off that without any regard to that person using it.
All right, Senator, I have a question.
Sure.
Is it not already part of Schedule II of the Drug Control Act, this fentanyl?
Mr. Chairman, I believe it is a Schedule II drug already.
So what does this bill do other than use the word weapons of terrorism?
I think that will allow the DEA and some of the federal groups to understand that Virginia's taking a hard stand, and that, Mr. Chairman, I served on a task force for the DEA, and I think there probably will be a lot more assets that will be available to us from a task force perspective as we start going forward on this. And I'm looking at Mr. Benjamin, and I don't know if you...
Mr. Chairman, I think that
Mr. Benjamin.
the answer to your question was what it does is increase the possible penalty. Distribution of a Schedule II controlled substance for a first offense would be 5 to 40 years in prison. Because this bill equates it with a weapon of terrorism, then it would be a Class 2 felony, which is 20 to life.
Well, let me ask you, is not fentanyl also a Schedule II of the Drug Control Act, Senator, Mr. Benjamin?
It is, Mr. Chairman. And so currently, the unlawful distribution of fentanyl would expose somebody on their first offense to up to 40 years in prison.
Okay, all right.
Mr. Chair.
Senator Morrissey?
Senator Reeves, thank you for bringing the bill, and I understand the spirit and why it was done. One of the charges of this committee is to make sure that it doesn't capture people that we don't want to capture. And because your language on line 44 uses the words sells, gives, or distributes, what that means is that college student at VSU or Virginia Union University or Virginia Commonwealth University that sells or distributes a modicum of this drug to another individual faces up to life in the penitentiary, or a minimum of 20. That's problem number one. Problem number two is if we were to pass this and a prosecutor indicted that individual, that may, and it's only a modicum that they distributed, it kind of chills their right to perhaps take a jury trial or go to trial, and that it captures too many people that we don't want to capture. Maybe in another iteration of this bill where it just focused on those heinous individuals who manufacture the drug, perhaps in or out of the United States, and then it might have a greater flavor.
All right,
Thank you.
Senator Stewart, you have a question?
Mr. Chairman, I've got kind of. Senator Reeves, it appears to me that you are trying to get at people that are intentionally putting fentanyl in drugs, knowing that it kills people. I'm just wondering, which I think is a good thing to try to get at because it's a scourge on our community right now, and we all know it. And I think we have a responsibility to try to do something about it. So I'm wondering how you would feel, since it's your bill, if we took out sells and gives on line 44 and on line 45 before contains put knowingly. And so what your bill would then say, anybody who knowingly manufactures, does this knowing it contains fentanyl and distributes it would be guilty of a Class 2 felony. And that may get around all the objections here.
Mr. Chairman, I'm not averse to a friendly amendment.
Can we take this by temporarily to work on something like this and move on with some other cases?
Yes, sir.
Take it by temporarily, is that right?
Sure.
Okay. Okay, all right. The next person, let me see, is Senator DeStef. Is he here? Okay, Senator DeStef, you have, how many bills do you have?
Mr. Chair, members of the committee, do I have a substitute? I don't
Yeah.
think so. No, there should not be a substitute, an amendment.
1296.
The original bill.
Okay, 1296.
So 1296. Basically, with the increase of crime since 2021, when we increased the level
Mr.
of
Chair,
petty larcenies
I'm
from
sorry.
$500 to about.
Mr. Chair, don't we have two other bills just like this or
Yeah.
similar to this?
Right, Mr. Chair, Senator Steph presented this bill, I believe, a couple of meetings ago, and Senator Peake asked a question, if this is related to the smash and grabs, don't we have another bill that relates to this? And Senator Stewart has a bill, 1396, that deals with organized retail theft. So I thought the thought was that this committee would roll Senator Steph's bill into Senator Stewart's bill. That was discussed at the last meeting, since Senator Steph's bill seems to be getting at the retail theft, the smash and grab, so to speak.
But, Mr. Chairman.
Senator Steph.
Or Charles, I really didn't want this focused on specifically smash and grab. I want this focused on thefts where, A, people walk into a store, load up a cart, and walk out, not smashing anything, they're just doing it.
Same thing.
And, or they're going and breaking into somebody's car during Christmas time and stealing stuff out of their car. If it's the same thing of Senator Stewart's bill, I've not read his bill. I was trying to figure the simplest way possible to do this.
Mr. Chairman?
Yeah, Senator Stewart.
Just for Senator Steph's benefit, the bill I'm carrying actually is a result of the work group that was held over the past year that was put together by Senator Barker and
Okay.
Delegate Byron, and I think your bill, the language would be included in the bill I'm carrying. Charles can correct me if I'm wrong.
Mr. Chair, it's a little bit different in the sense of Senator Steph's bill reduces the larceny threshold to $1,000 to $500. But what your bill does, it allows the aggregation of certain petty larcenies to be aggregated over a period of time, so you get over that threshold. So it does a similar thing in a different manner.
Understood. Mr. Chairman, I'm happy to roll the bill if that's the case. I just hadn't read Senator Stewart's bill.
Let's have a motion. To roll the bill? All right, Senator Steph's Senate Bill 1296 is rolled into Senator Stewart's bill, which is what? 1396. Is there a second?
Second.
All in favor of the motion to roll the bills into Senator Stewart's bill, say aye. Aye. All opposed, no. Motion
I think
carries.
it's a recorded vote.
Mr. Chair, there's a recorded vote.
Okay, I'm sorry, it's got to be recorded vote. All in favor of the motion to roll Senator Steph's bill into Senator Stewart's bill, vote aye. All opposed, no. Vote aye.
Senator,
Mr. Chairman, members of the committee, thank you very much for your
ayes
time.
15, no zero.
Okay, thank you.
Mr. Chairman,
Okay.
Mr. Chairman,
no,
down here.
Senator
When we get to take up Senator Stewart's bill, I have a different way to go at the same problem with 896. So they probably ought to be considered at the same time to figure out if they're simultaneous approaches or pick one or the other.
So the 896, but I think the next person is, what do you want to do with 896?
Just, I want it to be considered at the same time we take up Senator Stewart's bill because
Oh.
it's a different approach to attack
Senator
the same
McDougal.
problem.
Well, we looked at the bills, we looked at all three of them together.
Okay. All right, now Senator Chase, you have a bill, two, I think, two bills. Senate Bill 805, control of firearms by localities, and 1488, firearms removal of person posing a substantial risk. Okay, Senator Chase, 805.
All right. Thank you, Mr. Chairman, members of the committee. Senate Bill 805 seeks to repeal a law that we passed back in 2020 that gives the localities the ability to create gun-free zones. And what I would like to do is talk to you from a personal perspective of someone who carries. Before I entered the General Assembly, I didn't carry. When I got into the General Assembly, I started to carry because I was even attacked 3 different times on Capitol grounds. Capitol Police, as good as they are, they cannot be everywhere all the time. So I got trained, I learned how to carry, and so whether I go to the gym or I go to Walmart, wherever I go, I always carry. But what happens is, when you go to localities like Richmond, where I work, they tell you that you cannot carry a firearm. Now, what happens to someone like myself, small female, who has PTSD because they were assaulted on Capitol grounds where we should have protection and law enforcement? What happens?
Okay, any questions of the patron?
Yeah, I'm
Yeah,
working on it.
Go ahead.
If you could let me finish my story
Yeah,
here.
Go ahead, tell us your story.
The concern is this. I should, as a law-abiding citizen, be able to protect myself. Creating gun-free laws only disarms law-abiding citizens who are desiring to protect themselves. Now, if you've never been attacked, you may not understand this. But for the many women and men who have been assaulted and have these issues, it is an important issue. And whenever you require law-abiding citizens to disarm, put their weapon in their car, lock it up, and hope that it doesn't get stolen, and then walk through the streets of Richmond, where we know there's an increase in crime, that's a problem. And so what this bill does is it seeks to reverse the gun control law that we passed back in 2020, which is a clear violation of our Second Amendment constitutional rights.
Mr. Chair, I'm not sure the membership of this committee has changed since 2020. I think we all remember the bill. We killed the same bill last year. We've killed a similar bill already this year. I think we ought to just take public comment and move on.
Anybody have any questions of the patron? All right, anybody wants to comment? Okay.
If anyone on Zoom would like, oh, we have several speakers on Zoom, Mr. Chairman.
All right, you get 30 seconds apiece.
All right, Vic Nichols, you may unmute and speak once you pop up as a panelist. Vic Nichols, you may unmute and speak.
Thank you. While the makeup of the Senate committee hasn't changed, nor has our want to be able to protect ourselves. Thank you.
Okay, next. Anybody else
Tai,
on
you
Zoom?
may unmute and speak.
Ty Mallory, representing the Virginia NAACP, and we oppose the bill. Thank you.
Okay, all right, next.
Valerie, I'm trying to promote you to a panelist. If you could accept the
Anybody on
promotion.
Zoom? Quickly.
Valerie, you may unmute and speak.
Valerie Slater, Rise for Youth. We oppose the bill. Thank you.
Okay, next.
That's all the speakers on Zoom, Mr. Chairman.
Okay, anybody want to speak in favor of the bill? If it's physically here, yeah, we know. Go ahead, Philip, how you doing?
Yeah, Philip Van Cleef, Mr. Chair, VCDL. Yes, we support the bill. In fact, in Winchester, so a couple of the provisions have already been struck down as unconstitutional. Thank you.
Okay, next, in favor of the bill?
Good morning, Mr. Chairs, members of the committee, Pat Webb, VCDL. I strongly support this bill. if it is allowed to stand, it will be challenged. It is being challenged in court now. You will save the taxpayers a lot of money
Okay.
by overturning this unconstitutional bill. In light of Bruin, we've seen that this bill is definitely unconstitutional, and we ask you support this bill. Thank you.
Okay, thank you. Anybody, go ahead. You support the bill?
Paul Teal, I'm here again. Was here a couple years ago and continue to stay after this bill. In fact, in Virginia Beach and the gun-free zone in that office building, 9 people were killed. The person who worked in there and killed those 9 people knew exactly that it was a gun-free zone. So let's stand up and let people defend themselves. Thank you.
Okay, thank you. Next, these are those against the bill, very quickly.
Mr. Chairman, we oppose, Andrew Goddard, Virginia Centre for Public Safety. We oppose the bill. We believe that the locality should be allowed to do what their constituents want them to do, and if that's affecting their public safety, they should be able to do whatever they choose.
Next bill, next person.
Mr. Chairman, members of the committee, Mark Flynn on behalf of the Municipal League, we oppose the bill. Thank you.
Okay, next.
Mr. Chairman, members of the committee, Chris Sigler with Fairfax County, we also oppose the bill.
Okay, next.
Yes, thank you. Portland Evans Johnson, I support the bill, and Senator Chase is phenomenal, and so is VCDL. Thank you.
Okay, thank you. Next, Laurie.
Good morning, Lori Haas with Hopkins University. We oppose the bill. Recent studies show that expanding concealed carry actually increases crime in jurisdictions that move towards looser and looser regulations with regard to where and who and how can carry a concealed firearm. Thank you. We oppose the bill. We hope you will too.
Everybody who's had something to say has already said it. Is there a motion?
Mr. Chairman, just a final comment if I could. One of my biggest concerns, and I realize it's running statewide, is for those of us who travel across the Commonwealth into different localities, different jurisdiction, you're creating a patchwork of confusing legislation, which even the most conscientious law-abiding citizen has difficulty complying with. Thank you.
Okay.
And with that, I ask that we support the bill.
Okay, it's been moved and seconded to pass the bill by indefinitely. Anybody want to speak? All in favor of the... Okay, substitute motion that the bill be passed. So the motion is moved and seconded that the bill be reported and re-referred to finance. All in favor of the motion for report, vote aye. All opposed, no. Yeah, PBI.
6, no.
This is to report the bill. Report the bill. Strike the bill. All right. The motion is to report the bill.
We're good with that.
All right, report the bill, vote aye. If not, vote no.
Ayes 5, noes 10.
Okay, the bill is not reported. The primary motion is to pass the bill by indefinitely. All in favor of the motion to pass the bill by indefinitely, vote aye. All opposed, no.
Ayes 10, noes 5.
Okay, the bill is passed by indefinitely by a vote of 10 to 5. Thank you. Amanda, Senate Bill 1488, firearms removal from persons posing a substantial risk.
Thank you, Mr. Chairman. Senate Bill 1488 is a bill that you all have seen. It's commonly referred to as red flag laws. And just a couple concerns that I want to point out since we've passed this legislation in 2020. First of all, we have TDOs. If we have someone that has serious mental crisis and they need to be taken into custody, we already had a law prior to red flag laws.
Mr. Chair, Senator Chase, you understand that if somebody's TDO, they lose their rights to possess a firearm until they prove to a court that they are restored.
Yes, Mr. Chairman, Senator Deeds.
The red flag bill only removes a person's gun potentially for 30 days.
Mr. Chairman and Senator Deeds, actually, without any due process, any Virginian can completely lose before even going before a judge or a magistrate for 14 days. That is un-American to go in and seize someone's weapons.
Have you ever tried to use the red flag law on anyone? Have you ever invoked the red flag bill called on one of your former employees?
No.
You have not?
No.
Okay. All right. Okay. Is there any further questions of the patron?
Cree, I mean, if you're going to ask her about that, something's been distributed. I don't know whether she's seen it, and she, in fairness, ought to.
Yeah, have you seen the piece of? Yeah, yeah, Senator Chase, yeah, there's a person has distributed document.
No, this is incorrect. This is from a disgruntled employee that's sitting here in the audience. I have never invoked red flag laws on any employee, and I go on the record for that.
Okay, all right. Any other questions? Now, does anybody want to speak in favor of the bill, very briefly?
If anyone on Zoom would like to speak in favor of the bill, please
Could I
raise your hand
finish presenting my
electronically.
bill,
Yeah,
please?
go ahead, Senator Chase.
Honestly,
Senator Deeds, if you don't mind, please,
Yeah,
maybe
go ahead.
I could just tell you, I'll just keep it brief. One of the concerns that I have about this bill is that even if that person has not been convicted of a crime or charged with a crime or even accused of a crime, this can be used for nefarious reasons, Mr. Chairman, and that's what I'm really concerned about. Virginia judges have issued at least 327 emergency substantial risk protective orders, which allow police to temporarily confiscate firearms to address an immediate risk. The problem that we have is that we have too much authority given to a handful of people to indiscriminately take away a person's Second Amendment rights. And I'm talking about the 14 days where they haven't even gone before a judge, and their firearms are completely being seized. No due process. It's like the Gestapo coming in your home. You have no idea that they're coming to take your guns. You have no idea why. And that is un-American. We already had temporary detention orders issued by a magistrate that requires an individual to be held in a facility for a period of 1 to 5 days if they are in that much danger to their society. Red flag law confiscation orders turn our legal system on its head. For centuries, the standard has been innocent until proven guilty. Red flag laws reverse the standard into guilty until proven innocent because they throw real due process out the window, revoking someone's Second Amendment rights without a jury trial or right to counsel. Not surprisingly, at least a third of red flag laws are initiated against innocent people, and the guns which are erroneously confiscated can take up to 9 months to return. These laws have even been used to disarm women, such as the case in California where a cheating husband and the state's red flag law to disarm his wife, who was a concealed carrier.
Okay. Can you wrap it up?
I can wrap it up. The thing that concerns me the most is that for 14 days, a person can be accused, can have the government should not be seizing weapons from people who haven't been convicted of a crime. Nothing more than a way to justify seizing people's firearms under the color of law. And this law is a poor excuse to take people's guns and is not designated in any way to address real, concrete mental health issues. And I would also argue is a violation of the ADA, the Americans with Disability Act of 1990, which is a federal civil rights law that provides powerful legal protections for individuals. I'd also like to go back and cite a recent court case, even in New York. This New York State Supreme Court agrees that red flag laws are unconstitutional. Even the New York State Supreme Court agrees red flags are unconstitutional. They allow the government to take away our guns without any due process for up to 14 days and potentially longer, placing the burden on the unsuspecting individual who has not committed a crime. And with that reason, I ask, Mr. Chairman, that we support this bill.
Mr. Chairman. Let me say that we have a lot of bills today, and we don't have but so much time, so we need to move it along quickly.
Mr. Chairman.
Yes, Senator Sherrill.
Thank you, Mr. Chairman. I think the committee knows we've already passed legislation this session modifying, expanding, or, well, clarifying, not expanding, but clarifying what the red flag law is on third read today. We've already taken testimony on red flag. I don't see why we need to take testimony on something that we've already endorsed and passed this session. I would move to PBI the bill.
Is there, for any, it's been moved and seconded to pass the bill by indefinitely. Is anybody supports the bill, raise your hand if you're here. Anybody oppose the bill, raise your hand. Okay. The bill has been, motion been made to pass the bill by indefinitely. All in favor of the bill, vote aye. All opposed, no. PBI, I'm sorry, the PBI of the bill. But yes, if you want to pass the bill by indefinitely.
Ayes 10, noes 5.
Okay, thank you, Senator Chase. The bill is passed, bill indefinitely. The bill's been passed by indefinitely. Okay, thank you very much.
Thank you,
Next
Mr. Chair.
person, Senator Eben, I believe. Yeah. I'm sorry? I can't hear you.
I think they've got Senator Reeves's bill.
We'll do yours now, Senator Eben.
Okay, I have a consolidated set of line amendments, some of which you adopted at the last meeting, and one additional one. The additional one removes the language that you had questioned, Mr. Chairman. This is Senate Bill 1093.
Yeah, Senate Bill 1093. Senator, it has something to do with notaries. Go ahead.
I don't know if you want to take up the line amendments. I can answer any.
So what do the line amendments do, briefly?
Most importantly, it takes into account your objection of not keeping records of notary acts that were not completed on lines 153 to 157. It says that you have to take the training within 30 days of applying to be a notary, and that it gives a delayed enactment date so that the Secretary of the Commonwealth would have time to set up a training and an examination.
Okay. Is there a motion to adopt the amendments? Is there a second? All in favor of the motion to adopt the amendments, say aye. Aye. All opposed, no. Motion carries.
Okay,
So
thank you. Thank you,
amended
Mr.
motion. Amended bill.
Thank you, Mr. Chairman. So the bill basically requires that notary publics undergo some training and an examination set up by the Secretary of the Commonwealth, has a delayed enactment date so they could do that, and also that they would keep a journal of notary acts as they're required to do now for electronic notarizations. And that's
Who's asking for the bill? Yeah, Senator, who's asking for the bill?
This came from the prior Secretary of the Commonwealth, and I consulted with the current Secretary of the Commonwealth and wrote it to their specifications.
Okay. Any questions?
Mr. Chairman.
Yeah, Senator Norman. Senator Peterson.
Senator Evan, where is this coming from? I have a number of notaries in my office. Is there a problem?
There's a National Association of Notaries, and the prior Secretary of the Commonwealth asked me to carry this. Last year, I delayed it for the current Secretary of the Commonwealth to have adequate time to review it. Basically, it says that we would join a variety of other states in requiring some training and a test for notaries to make sure that they know what they're getting into and that they keep records of their acts.
Okay, I understand that's what it is, but we have notary of thousands and thousands of notaries, and I guess what I'm asking is, what's the problem we're trying to solve here?
We're trying to professionalize in line with other states, including California, Colorado, North Carolina, Louisiana, Maine, and about New York, Montana, Nevada. A huge number of states require some kind of notary training and examination. And notaries are entrusted with important responsibilities. Just make sure that they get it right.
Mr. Chairman.
Okay, Senator McDougal.
Senator Eben, I received some calls from attorneys at the end of last week. So if you have a real estate transaction and the attorney or their assistant is in there notarizing documents that could at times be 10 documents per individual party. So if you have spouses that are purchasing property, are they going to have to then make 20 different records of documents that they've notarized?
A notation in their journal that they notarized 10 documents for a party, what the purpose was.
Okay, any further discussion? Yeah, Senator, I'm not sure I see what the reason for the bill is, quite honestly.
The prior Secretary of the Commonwealth thought it might be a good idea to join the other states that require professional standards for notaries in Virginia, and this Secretary of the Commonwealth agreed to the provisions that were remaining in this bill before you.
Any discussion? Yeah, Senator Oberchain? No.
Just, and real quickly, I'm probably not going to support it anyway, but Adam, you narrowed down in your amendment the journal entries required for actual in-person notaries, but expanded the big list of everything you've got to record is still there for electronic notaries. So it looks like a in-person notary doesn't have to record very much. Electronic notary has a pretty long list. Any reason for that?
We took this from the national standards and ran it by two secretaries of the Commonwealth. I'm not a notary myself.
Okay. All right, any further discussion? Is there a motion of any sort? Anybody want to speak in favor of the bill? We have a short time frame. Is there a motion? All right, it's been moved and seconded that the bill be passed by indefinitely. Any discussion? All in favor of the motion to pass the bill by indefinitely, vote aye. All opposed, no.
Senator Lucas. Ayes 9, no 6.
Thank you, members of the
The
committee.
bill has been passed by indefinitely. Thank you, Senator Evan. All right. All right, the next bill, Senator Reeves, we'll do your bill.
Mr. Chairman, do we have a?
You got a bill, you got it. Okay, we've got a substance being printed out. Let's put it off next. We have a subcommittee report. Senator Sherville, this morning he had a criminal law subcommittee. You have a report?
Yes, Mr. Chairman, we heard one bill this morning. It was Senate Bill 1436 by Senator Donovan. The committee may recall that that bill was heard briefly in committee, and then when a substitute was presented, it got referred to the criminal subcommittee. Basically, the bill reinstates requirements of testing for sexually transmitted diseases after somebody is arrested for a specific list of felonies or misdemeanor domestic assault if, it allows a Commonwealth attorney to file a motion to have a hearing to have somebody tested if they've been charged with one of those felonies or domestic assault, and they can show under circumstances that there's a possibility that the nature of the crime could cause a sexually transmitted infection. The committee took some tests. We made a couple amendments. We've been through several drafts. At this point, I think the key language is on line 65 through 67, which is the list of sexually transmitted infections that this would apply to, which is a little different than the policy we repealed in 2021. And the bill, as amended, also has a lot of additional procedural safeguards that the former statute, the repealed statute, did not have. So that, for example, if the Commonwealth Attorney is looking to have this testing done, there has to be a hearing. The accused person can participate in that hearing. And there has to be a finding, but there has to be evidence presented to a court to find it was necessary to do this. So I think the bill was reported by the subcommittee 6 or 7 to 0. 7 to 0, and I would move we report the bill.
It's been seconded, moved and seconded that the bill, first of all, we need to adopt the substitute.
I move to adopt the substitute.
All in favor of the substitute being adopted, vote aye. All opposed, no. Did it have to?
Mr. Chairman, I'd move to report the bill.
Motion carries.
And I'm sorry, report to finance.
The motion's been made to report and re-refer to finance the substitute. All in favor of the motion, vote aye. All opposed, no.
Ayes 15, no 0.
Thank you, Senator Donovan.
Thank you,
Appreciate it.
Mr. Chairman.
Thank you.
Members of the committee.
So now we move on to, where are we, with Reeves? How are we doing? Okay. Senator Reeves?
Got it?
We still got the bill? Okay, somebody's got to bring it down. It's not quite ready. That's okay. Let's wait till it gets here. Okay, we'll move on then. Senator Hashmi, do we have a bill? Okay, Senator Peterson, you can present Senator Hashmi's bill. That's Senate Bill 931.
Yes, sir. Senate Bill 931, I'm going to do this based on memory, was the bill that dealt with irrestorably incompetent defendants and what we do in those situations. Is that the one, Charles?
That's correct, Mr. Chair.
Okay, you look like you're about to pass something out.
Yeah, Mr. Chair, so after the Civil Subcommittee, stakeholders got together and produced I'll say a compromise. Not everyone's happy with it.
Okay.
But there is a compromise substitute.
I think the substitute is to pass the bill by.
That sounds great, Mr. Chair.
Okay, so what I'm going to suggest we do is, and just to set the stage, we had a long discussion in our subcommittee, and I think we were unable to come to an agreement on how you balance someone that's a danger to society versus what you do when someone's never been adjudicated of a crime. And you can't just hold them indefinitely. It's just not how it works in America. So I think at this point, we'd like to pass the bill by with a letter, I think, to DBHDS. You might want to check that, but a letter from the chairman of DBHDS to try and come back with some solutions on this issue of irrestorably incompetent.
Yeah, so the motion is, yeah, Senator Stewart?
Mr. Chairman, I would like to second that motion. Senator Peterson and I think were the committee. And we discussed this for a great deal of time.
We did.
Heard from some very intelligent people, and he and I couldn't come up with a solution, quite frankly. So I would like to second his motion.
Right.
Okay,
Thank you.
It's been moved and seconded that Senate Bill 931 of Senator Hashmi be passed by indefinitely with a letter to the Behavioral Health Care, is that right? The Behavioral Health Commission.
Right.
So the bill would be passed by with a letter to the Behavioral Health Care Commission to study the matter. All in favor of that motion on Senate Bill 931, vote aye. All opposed, no.
Ayes 15, no zero.
15-0. The motion carries. Okay, Senator Mason has some bills, but I think we're going to pass them. These bills go past with Senator Mason?
You know, it's funny.
Huh?
It's almost like.
Okay, all right, we'll go, now we're back to Senator Reeves' bill again. Senator Reeves, we have the substitute in front of us, Senate Bill 1188, dealing with weapons of terrorism.
I mean, we just resolve.
Where did it have the knowing part here?
Line 42, Mr. Chairman.
42?
Right, Mr. Chair, so the bulk of the substitutes in lines 42 to 45, which says that any person who knowingly and intentionally manufactures a weapon of terrorism, when such person knows that such weapon of terrorism is or contains any mixture or substance containing a detectable amount of fentanyl. So, in other words, a person must knowingly, intentionally manufacture, mix, or come up with a substance, and then they have to know that we eliminate distributes, but if the committee wants to add distributes back in, we thought it was just manufacturers, but we can add distributes. Okay.
Okay, we have the.
Mr. Chairman.
A couple of pieces of paper here. Which one is this?
Mr. Chairman.
Yeah. We're just saying, which one is it, Charles? I got three of them.
They're all the same.
Oh, they're all the same. Okay. All the same. Yeah, Senator Stewart.
Mr. Chairman, the operative language starts on line 42. The only change that I would ask the committee to consider would be any person who knowingly and intentionally manufactures or distributes. So either way, you are knowingly and intentionally manufacturing or knowingly and intentionally distributing this, and I think that was the language I was trying to get to.
Okay. First of all, let's adopt the substitute. Motion. All in favor of the motion to adopt the substitute, say aye. Aye. All opposed, no. Now, the substitute's in front of us, and Senator Stewart wants to add an amendment on line 42, which says any person who knowingly and intentionally manufactures and add their language or distributes after manufactures or distributes.
Mr. Chairman.
Yeah, Senator Stewart.
It probably should say knowingly and intentionally manufactures or knowingly and intentionally distributes.
Okay.
I saw Mr. Benjamin leaning forward and
That's right, Mr. Chairman. Here's my concern. The young people, the teenagers who are most at risk are those who are going on the internet and knowingly ordering pain pills from China or from some dark website and then using them themselves and selling them to their friends. And the problem is defining when they know or should know that what they get off the dark web is in fact fentanyl. And many of them will acknowledge, sure, I know, and this is what we're using because regular heroin doesn't give us what we need. A lot of people are intentionally using fentanyl or counterfeit prescription drugs that they know contain fentanyl because that's exactly what they're looking for. And so I'm afraid that if we include distributes, you're picking up that category of people that we were trying to avoid it sweeping into a weapon of terrorism offense. That's my concern.
But the.
Mr. Chairman?
Yeah, Senator Short.
If I could respond to that, I think we want to sweep up the folks that intentionally distribute fentanyl. I understand Mr. Benjamin's concern, but if you know that it contains fentanyl and you intentionally distribute it to someone else, I mean, isn't that what we're trying to get at as much as the manufacturing? We took out the gives or the sells. I get what you're saying, but I mean, that's the part that's killing people.
Mr. Chairman, it is, and my views are tempered somewhat by having lived through the crack days of the 90s, when crack was the demon drug, and we all had the same conversations about crack. And so I'm concerned about the unintended consequences of a 20-year minimum sentence for a college kid who orders something under suspicious circumstances and is hence chargeable with knowing,
Mr. Chair,
that it contains fentanyl.
Yeah, Senator Peterson.
Oh, I'm sorry, Senator Norman may have been ahead of me.
Yeah, Senator Norman.
No, I do want to speak.
Mr. Chairman, just living in the real world on these issues, a couple of things. First of all, it is very challenging to work your way up in the distribution to get to the manufacturers. That is tough. The second thing is that on the street retailers, there's a fair amount of it is being sold and distributed out there, but those street retailers are not necessarily aware that fentanyl has been laced in there, and that middle person in the distribution chain is doing it unbeknownst. And for those of you who've ever done it, it only takes that much to kill you, the tip of a pin.
Okay, so we have a motion
Mr.
in
Chair.
front of us. Yeah, Senator Peterson.
I want to speak to this because I was here in 2002 when we passed this anti-terrorism statute. I remember it very clearly. And it is true, part of it had to do with the 9/11 attacks, part of it had to do with the anthrax that was sent through the U.S. Postal Service that was used as a way to try and intimidate. And whether that was terrorism or I don't know. I don't think we ever figured out. And I think that's actually accurate because I think the use of fentanyl to unknowing users in a lot of ways is similar. I guess my problem is, and I'm over here with Senator Cervell trying to do some research, is that Class 2 felony, I believe, is 20 years to life. Right. Which, one, that's going to be a heck of a cost. Two, I don't want to say overkill because I'm not in any way dismissing or discounting fentanyl. I think people that put it on drugs or release it into the population, frankly, if they kill somebody, they should be charged with, in my opinion, at least second-degree murder. It may be a little much. If you might be amenable to making it a Class 4 felony, I think I could vote for this, and I think we can get it out of here. I'm just not ready to do a Class 2 felony, which again would put it at the same as a second-degree murder just automatically.
Mr. Chairman,
Yeah,
this committee is pretty smart, and I spent 10 years on this committee, and there's some good attorneys here, and I'd consider that a friendly amendment, but I think what Senator Stewart is saying does hit to the problem itself, and you all that defend these charges, and some of you all that have prosecuted on these charges, I do believe it's a higher level of evidence that you have to get to that point.
I get it. I'd like to move to amend it to be a Class 4 felony, understanding we're starting a conversation here, but that would put me in a position to vote for it.
Okay, we
I'll
have
make that motion.
First of all, we have an amendment to the bill on line 42 to knowingly and intentionally distribute after manufacturing. And Senator Stewart, you accept the modification, Senator Stewart?
I'm sorry.
Will you accept the modification to make it a Class 4 felony also?
I'm fine with that if it's okay
Oh,
with the patron.
okay.
My motion was to.
Why don't we just roll the amendments together?
All right, so we have an amendment that says knowingly and intentionally distribute after the word manufacturers on line 42 and change on line 45 from a Class 2 felony to a Class 4 felony. That's the motion, right?
Yep.
Okay, all in favor of the motion, vote aye. Aye. All opposed, no. Motion carries. Okay, so we now have a bill that looks like it's in pretty
Mr.
good
Chairman.
shape. Yeah, Senator
McDougal.
McDougal.
Mr. Chairman, I welcome the comments of Senator Peterson. There was a bill that did not pass this committee that said if you were a distributor, sold the drugs, and you weren't physically present when the person died, you could be charged for homicide. Today, if you are using with a friend and they die, you can be charged for homicide. So the bill would have actually reduced the penalty on people that were using together and focused on the distributor. This committee chose to kill that bill. Mr. Chairman, this is an opportunity. Fentanyl is killing more Virginians than gun crimes and traffic accidents together. We need to tackle it. So if you didn't like the one way, this is a way to make it happen. Try to make sure we get fentanyl off the streets, keep our kids alive.
Mr. Chairman.
There's a motion. Yes, Senator Serval.
Thank you. I have a question for council, and then I think I have thoughts. But my question for council is, the distribution of fentanyl is already a felony, manufacturing and distributing. So am I correct? Does this create yet one more felony for the same thing? So in other words, somebody will already get charged with manufacturing, distributing a controlled substance, and they'll get charged with this on top of that? I mean, under block work or whatever, I mean, it looks to me like it talks about, I haven't had a chance to compare the language, but it talks about manufacturing, distributing, yada,
Mr.
yada,
Chairman,
yada.
the answer is yes.
Okay. Mr. Chairman?
Yeah, Senator Serval.
Thank you, Mr. Chairman. I mean, I like everybody here appreciate the havoc that fentanyl has reaped on our population and continues to cause. But, you know, we've sang this song or seen this song, heard this song before back in the 90s. And with, from my perspective, over criminalizing and over penalizing the distribution of drugs. I mean, you know, we got into this mess over crack back in the 1990s, and every study I've ever seen says that making things jacking up the consequences typically has very little to do with deterring or preventing crime. Most of it has to do with putting money into detection and conviction. The certainty of being charged and convicted deters crime, not the quantum of punishment or creating new felonies or whatever. And I just don't see this as being a solution to the problem. I think our time would be better spent focused on more money into enforcement or something like that in this. And for that reason, I'm reluctantly opposing this particular method.
Okay, I think we have a motion, don't we? Been moved and seconded that the substitute be reported and re-referred to finance. All in favor of the motion, vote aye. All opposed, no. Where's it?
Senator Sir.
Okay.
Ayes 14, noes 1.
Okay, 14 to 1, the bill
Thank you,
is
Mr. Chairman,
reported and
members of the
referred.
committee
Thank
for
you,
your help.
Senator Reeves. Okay, moving on to committee members. Oh, do you have Senator Mason?
Thank you, Mr. Chairman. Senate Bill 1510 comes as a recommendation of the Behavioral Health Commission, and I think we have a line amendment squaring up something at the end of the bill. Is that right, sir?
Mr. Chair, I have two line amendments. The first one is on line 10 after with, strike clause 2 of, and then on line 123 after may, strike Romanet 1, rescind an order for outpatient services in accordance with the procedures set forth in 37.2, 817.3, or through the Romanet 2. And from what I understand, these are largely technical amendments. There was a The 37.2, 817.3 section was repealed, and for whatever reason, it wasn't dropped out of the bill when it should have been.
That's
Okay.
my understanding.
Is there
Thank you, sir.
a motion? It's been moved and seconded that the line amendment be adopted. All in favor say aye. All opposed, no. Motion carries. Okay, we got
Thank
a
you,
bill
Mr.
with
Chairman.
the
Mr.
amendment.
Chairman, you may remember a couple years ago, Senator McClellan brought a bill that allowed you to present evidence of mental illness in a trial, and you could be utilized and found not guilty. This bill expands on that just a bit from outpatient treatment beyond it, but also adds autism spectrum disorder. It was just figuring mental illness, and a lot of folks in these circumstances have autism and may be flailing and be charged with assault on someone, assault on a police officer. So it adds this throughout Throughout the course of the discussions, they were trying to determine whether it was specific or general intent. The patron came to the Behavioral Health Commission and said that she had intended specific intent. So we clear that up on line 21. The bulk of the bill then starts really around line 55, because there was no place that someone who had been found not guilty could be put under a treatment plan. And this is, we notice people, they are not guilty of their crime that had been entered in court, but they begin to decompensate and they need treatment. Well, because they're not guilty, there was no way to get them treatment. So line 55 begins to address that. Section G directs the outpatient evaluation and just the kind of the mandatory outpatient treatment. But then the bulk of the new is starting around line 84, 85. We tried to draw this as to the mandatory outpatient treatment process as possible. That plan is called out 85, 80 to 89. This begins the plan, the mandatory outpatient treatment type plan. And then the new things that the committee should look at is subsection D, because line 97 to 100 is where the new person engaged in conduct creating harm to self and others may be evidenced by recent behavior, attempting to cause or threaten to cause. So this is the place that someone who had been found not guilty, we are determining that they could be decompensating in a place that they need help, and that's what we're trying to get at in this circumstance.
Okay.
Mr. Chair.
All right, Senator Morrissey.
Good morning, Senator.
Morning, sir.
You're familiar, it used to be that in order to get evidence of mental health defalcations, and you had to plead not guilty by reason of insanity, and Senator McClellan's, and I think I added on to it, changes that, and it now allows any evidence of mental health to come in.
Yes, sir.
One of the problems with NGI was that it would allow a judge to put somebody in, for example, a mental health hospital, where they'd be essentially incarcerated. Quick example, individual was charged with arson, young boy, then young man, lit put a match to, he was 22, but he had traumatic brain injury to the edge of a curtain, but it just singed it. He ended up staying in St. Elizabeth's for 15 years. Every year it came in and the same attorney was appointed, got his fee, and the guy went on until I heard about it. Then we had a hearing, we got him out right away. Does this bill, because I see the word may on line 55, may enter an emergency custody order, would this bill allow any judge who presided over a trial where the defendant was acquitted because, and there was evidence of mental health issues, to put somebody into a mental hospital against their will for any period of time?
Mr. Chairman, Senator Morrissey, what this does is if you are found not guilty, would begin the emergency custody order. It allows the process to begin, but they're not automatically committed. The ECO process would be able to be begun and evaluated. Then you would have to move to the temporary detention order process, which is laid out and is per usual. This just allows, if someone has been found not guilty because of those conditions, you can, in fact, if you see them decompensate, begin the process. But if you go to G, you see, and Mr. Chairman, Senator Morrissey, you touch on a problem that we have, and that is the lack of community-based services. All right, but everything in this bill tries to move towards the outpatient treatment. And so it tries to set up a plan. It tries to deal with the Community Services Board. So it is not beyond the realm of possibility that this person may be found that they need to go to a state hospital. This bill does every single thing it can to try to make sure that this is done on an outpatient basis. But the whole bulk of it is when they've been found not guilty, there is no process if we believe they're decompensating.
Okay, Senator Morrissey, are you?
Thank you, that answers my
Okay.
question.
Look at
Because
language on line 109. It talks about outpatient services for 180 days, no longer than 180 days. You know, I will tell you precisely where this bill came from. I think there were 22 or 23 cases in the past year or so since the law was effective where the person was found not guilty. There was a mental illness. The person was in need of services, but they weren't really eligible. They weren't in emergency services for a TBO at the time. And so this legislation came from that. It might be imperfect, but that's where it comes from. Senator Stewart has a question, I think.
Thank you, Mr. Chairman. Mr. Chairman, I saw the language you're referring to, but it also says 180 days unless the order is continued.
And that language is over on lines 124 through 126, I think, how it can be continued.
And so I have a couple questions, Mr. Chairman, if
Yes,
I
sir.
may. So, Monty, how long? How long are they going to be held under the supervision of the court? And can the court hold them in contempt if they don't do this and actually jail them for offense they were found innocent of?
Mr. Chairman, I don't play a lawyer on TV or in front of this committee, and the brains behind the operation, Ms. Stanton,
Sarah Stanton,
may be able to help you with that.
Counsel may be able to answer the question. I don't know.
They are found not guilty of the crime.
Exactly. They're innocent or not guilty. I get that. So then are we then submitting them to the jurisdiction of the court, which could actually lead them to being incarcerated under contempt?
I believe it becomes a civil process rather than criminal, but like I said, Ms. Stanton.
Mr. Chair. Mr. Chair. Good morning, Sarah Stanton with the Behavioral Health Commission. It is unusual to be on this side of things. We conducted a study over the course of the last year on this issue, and the question before us was what happens to an individual who has submitted evidence of mental condition, which includes mental illness, IDDD, or ASD, pursuant to the legislation that Senator McClellan introduced 2 years ago. Those individuals who have been found not guilty of any crime following introduction of that evidence normally are allowed to go free with no additional requirements unless they meet the emergency custody criteria. That's existing law. That is existing law, and the emergency custody criteria would already be available if that person met the criteria. The issue we identified, it was identified in the courts committee and came to us, was that individuals who have gone through a trial and are found not guilty generally don't meet the ECO criteria at that time. So you have a small number. We identified 28 cases in which an individual was found not guilty and no additional services were required. This bill creates that process where we would allow the criminal court to order an evaluation of the individual. If that evaluation determines that the person meets the new criteria, which are set out in subsection D of the new section 37-828.1, then the Community Services Board would be required to develop a plan for services for that person and then file a petition in the civil court. So they would be subject to the civil jurisdiction. At the end of the duration of that order, if the person continues to meet the criteria set out in subsection D, there is the option to have that order continued. Those criteria, again, beginning on line 99, is that the person was found not guilty of any offense after a trial at which evidence of mental condition was admitted, The person has a mental condition. The person engaged in conduct that created a risk of harm to himself or others, which may be evidenced by recent behavior, including that conduct for which he was found not guilty of a crime. The conduct was related to the person's mental condition, that there is a risk that without services, the person's condition will deteriorate to the point where they will meet the ECO criteria, essentially, posing a substantial risk of harm to themselves or others, and that outpatient services could benefit them. So if at the end of the 180 days, the person continues to meet that criteria, it could be continued.
Okay. Mr. Chairman.
Yeah, Senator
I hate to interrupt,
Senator Sherrill.
Sarah, but I'm trying to get an answer to my question, and that is, even under civil contempt, you can be jailed.
Mr. Chair?
Yes.
Yes. So
Yes.
what
Okay.
happens?
That answers my question, yes.
You can be, but there's an.
Wait a minute, I'm not finished.
I'm sorry.
I had two questions. You've added people with autistic spectrum disorders under this bill, which in many cases are very different from somebody with some other type of mental condition. People with disorders under that spectrum oftentimes just react a little bit differently. That's right.
Mm-hmm.
And, you know, if you tell them to stop or something and put your hand on them, they don't like to be touched. And so they'll back away from you. And they may not comply with an officer because of that, but they're not violent, they're not aggressive or anything like that. They just respond to the world a little differently than other people do. So in this situation, you're including them, and they too could now be jailed if they don't comply with a program after they've been found not guilty in court. Am I reading this correctly? Am I reading it correctly?
Mr. Chairman, Senator Stewart, they are included already in the bill. We just call them out in a different way, and that's the idea. And you're right. On the back end, they'd be included in the mandatory outpatient treatment, but really this was just changing where we had them on the front end, that they could complain, they could say they're not guilty because of that.
And Mr. Chairman.
And that's existing law. I made a mistake there.
Mr. Chairman, finally, it's mandatory. So these aren't services that are being offered to people. These are services, and the court is saying, you must participate in this, and if you don't, I can find you in contempt, and I can jail you.
Yeah.
And they were found not guilty of a crime. So that is very troubling to me. You know, perhaps we want to make something voluntary or make services available, but I don't think we should be mandating this for folks who were not guilty.
Mr. Chair?
Yeah, Senator Morsi.
Here's another potential problem, Monty.
Mm-hmm.
The individual has produced, the defendant put on evidence during the trial, some that he was not guilty for reasons unassociated with his mental health condition. Yes. But his defense attorney also offered evidence, like Senator Stewart said, that he may have been on the autism spectrum. Here's the potential problem, and I need you to assuage me of this. Okay. That there is a degree or modicum of punishment associated with this if he's found not guilty because he chose to introduce evidence of mental health defalcations. Do you follow me? That's what I'm struggling with, and I think Senator Stewart was. We don't know why he was found not guilty, but he was found not guilty. He introduced evidence, and now he could face some type of punishment. That's what you need to assure me isn't the problem. You want to?
I have a question, Mr. Chair.
Go ahead. Does this have to go to finance?
No, I did.
If it doesn't have to go to finance, maybe we could pass it by to another day.
Mr. Chair, it does have to go to finance.
All right, okay, go ahead. Answer the question.
Well, after he, yeah.
You want to address it? Go ahead.
Mr. Chair, Senator Morsi, yes. So there is no, in the original rule of evidence that was Senator McClellan's bill, there is no causal connection called out between introduction of evidence of mental condition and the ultimate finding of not guilty. The bill does not specify that the finding of not guilty has to be a result of that evidence of mental condition that indicated the person did not have this ability to form the specific intent required for the crime. However, the evidence to be admitted in that trial does have to tend to show that the person could not have had the requisite specific intent. So it is not clearly stated, but there is that requirement that the evidence relate to their ability to form the specific intent. The other piece of this that may be relevant to this discussion is that the criteria that begins on line 99 does require that in order to be subject to one of these new orders requiring a person to participate in outpatient services, and they are anticipated to only be an outpatient evaluation and outpatient services, is that not only has the person been found not guilty and that they do in fact have a mental condition, but that they engaged in behavior that created a risk of harm, and that there's a substantial likelihood that absent services, they will deteriorate to the point where they meet essentially the ECO criteria. So yes, you are correct, but I want to make clear that there are some guardrails at least that were intended to address this
Senator
situation.
McClellan.
I have a related question. So in subsection E, lines 13 to 18, you're cross-referencing section 37.2808, which when I read that, as I understand it, whether someone has been arrested or not, there is a process for an emergency custody order. But what you're doing here is when someone has been charged and found not guilty of a crime, you're changing the criteria for an emergency custody order, correct? Because if you look at lines 105 to 107, slightly different criteria than what's in 37.2808. Am I reading this correctly?
You are reading, Mr. Chair, Senator McClellan, yes, this is different criteria than what you would find at the ECO. This bill would create a new process that is separate from the ECO process.
Mr. Chair.
Follow up, Mr. Chair.
Senator McClellan.
Why wouldn't you just use the current process? Let me explain. Here's my issue with this portion of the bill. Is this is continuing a public policy that I think is incredibly backwards by saying in order for someone to get treatment, they have to be part of the criminal justice system. And that's continuing to criminalize mental illness. When what we really should be doing is, if there's an issue with making sure everyone who needs an involuntary custody order gets one or gets treatment, we need to deal with it that way. It shouldn't be you were charged with a crime that you could not possibly have the mens rea and the intent to commit, and yet we're going to have a separate process to get you treatment that you need. We should just be focused on getting you treatment.
Mr. Chairman.
I think anybody in the world disagrees with that.
That comment by Senator McClellan tees up another issue for the committee. The reference just made was whether somebody has the requisite intent or mens rea. And the bill, unless it was changed, I think online, did you?
Senator Benjamin.
Where? It specifies that the intent for which evidence may be offered is the requisite specific intent. In specific intent is the intent to accomplish a specific thing. For example, the intent to kill, the intent to permanently deprive, everyone understands that. But in the fentanyl bill we discussed a little while ago is a perfect example of this, when this committee in the General Assembly criminalizes certain conduct or further punishes certain conduct. They are often, the General Assembly is often careful to add a mens rea, such as intentionally, unlawfully, knowingly, willfully, maliciously. Okay. Those are all forms of criminal intent or mens
Mr. Chair,
rea.
I hate to cut off the lecture from the professor, but can I make a motion on this bill? Well, there was no question. We were getting a lecture for no reason.
Well, he was telling us the problem.
Mr. Chairman, I would note that this is what I'm supposed to do, is explain differences.
Okay. All right, well, let's do this. I don't like the bill, and I would move to PBI. If Senator McClellan wants to salvage part of it,
Yeah.
then maybe we can carry it over and we can salvage part of it. I do not like this idea that someone who's acquitted is, and I have a child that's autistic, that somehow that can be used against them and keep them within the framework of the court when they have been acquitted.
Right.
So having said that,
Wait.
I will allow
Wait.
McClellan to salvage whatever is worth salvaging.
Well, Miss-
And I don't need a lecture.
Mr. Chair, I agree with Senator Peterson that that part of the bill should come out. There are two things that the bill does that clarifies the original intent of the bill that we passed, that I put in, by making clear that autism spectrum disorder is also one of the conditions you can provide evidence of, and that this is for specific intent crimes. That we intended that in the original bill. The Behavioral Health Commission thought it was not clear enough. So that portion of the bill, I think, is worth advancing, and then the rest of it just strip out.
Mr. Chairman.
We got one motion to pass the bill by indefinitely. Senator Stewart.
I want to second Senator Peterson's motion. With all due respect to Senator McClellan, I brought the bill years before Senator McClellan brought her bill to allow people with autism spectrum disorders to be able to do this, and I think it's perfectly clear.
Okay.
This bill gives me a great deal of concern. I know you've tried hard. I know there's been a lot, but this bill needs a lot of work. A lot of work. It's got a lot of issues with it. So I hope.
Mr. Chairman, may I speak to it real quick? So all of you have determined you do not like this approach. Please spend some time with us in the next year determining an approach that we can get to. There are 28 people that were found not guilty that ended up decompensating, and where did they probably end up? Back in the criminal justice system. This is an effort to try to get them help. And yes, absolutely, we should be able to get them help without running them through the court. But we can't. All right, so this was an effort to get them help when we see them decompensating. And it was 28 examples brought to us by the court. So I understand that this isn't right. I'm not the guy to bring it anyway. But please take a look at this in the off season and let's figure out how we get to helping those 28 people.
Mr. Chair,
Thank
speaking
you,
of the
Mr.
motion. Just speaking 15 seconds to the motion, Monty, one of the things that Senator McClellan brought was that we're only getting mental health after the person has gone through the criminal justice system. Perhaps, and I'm happy to participate in this, it's at the early on in the process when the person is arrested or indicted that we start to get them that degree of help.
Yes, sir. And you're going to see a civil process next meeting and a couple of examples of us trying to get there because we're not there, and Senator Deeds is providing great leadership to try to get us there, but you're exactly right.
Seconded to pass the bill by indefinitely. All in favor of the motion, vote aye. All opposed, no. Motion's been made to pass the bill by indefinitely.
Mr. Chairman?
Yeah, just a minute.
Ayes 11, noes 4.
11 and 4, the bill's been passed by indefinitely. Senator Serval?
Thank you, Mr. Chairman. The complexity of this seems to me tailor-made for the Crime Commission. I mean, do I have to, can the chairman just write a letter to the Crime Commission requesting they think about looking at this?
I'll be happy to write a letter to myself, since I chair the Crime
The
Commission.
commissions can all join the party, Mr. Chairman. Thank you, Mr. Chairman. Members of the committee.
Okay, thank you very much, Senator Mason. All right, next bill, Senator Boysko has two bills. I'm just going down the list here. Senate Bill 1159.
Actually, Mr. Chairman, I have three because we did not complete 1156 last week, but we can do that last if you want to do that. 1159. I have an amendment in the nature of a substitute before we get started about that one.
We'll pass the amendment in the nature of a substitute for 1159.
Yes, sir.
Which deals with fines and costs, et cetera.
And if the clerk could read the changes, I'd be grateful.
Mr. Chair, the substitute makes a couple of changes. Primarily, excuse me, one moment. On the bill as introduced, it strikes the language on lines 40 through 42, and then inserts on the substitute before you, so inserts on line, or after line 86, subsection E, and reads, notwithstanding any other provision of law, no fines, costs, forfeitures, penalties, or restitution imposed in a criminal case or in a case involving a traffic infraction shall be subject to collection by the attorney for the Commonwealth or any collection agency on behalf of the attorney for the Commonwealth, including any private attorney and private or public collection agency, nor shall any collection fees, including administrative fees, authorized by Section 58.1, 3958, or any other fees related to collection activities be assessed, 1, for any period during which the defendant is incarcerated, and 2, for a period of 180 days following the date of the defendant's release from incarceration, if the sentence includes an active term of incarceration.
Okay, is there a motion to adopt the substitute?
So moved.
Second, any second, all in favor of the motion to adopt the substitute, say aye.
Aye.
All opposed, no. We have the substitute before us. Any questions, Senator Boysko?
Mr. Chair?
Yeah, Senator Obenshain.
Just real briefly, and I'm just trying to understand this. This prohibits collection during that period.
Yes, sir.
So what if the defendant has assets, significant assets? We can't collect restitution for the victim of that crime until they get out?
Mr. Chair,
Yeah,
Senator
Boysko.
Obenshain, if the defendant has the funds, they're likely to go ahead and pay it. But the Commonwealth,
Sure.
the Commonwealth, you think that's funny?
I do.
You know what? I pay my bills on time as much as I'm
That's why you're not in
possible.
prison.
Okay.
And can we all celebrate that? So currently, the law requires court debt to be sent to collections 90 days after someone's sentenced if they have not paid their court debt in full or started their payment plan, and the interest doesn't begin until 180 days. The bill actually, because we start the collection agencies at 90 days, they take a 35% fee from the collected debt, and it is only offset by the 17% collection fee charged to people with convictions. The rest of the fee contracted to the collection agency is paid by the Commonwealth. And so if we could give them a little bit more time, one, we could save the money that the Commonwealth's going to be paying on those collection debts and give them a chance to get on their feet.
So-
I have some people here to speak who might be able to answer more technical questions than I am, who are more familiar with the situation, seeing that
Mr.
I haven't gotten in trouble in this
Senator
way.
So, and just to short circuit it, and in case somebody who's going to testify wants to address this, so let's just say we have a Virginia Bernie Madoff, okay? And you've got victims of his scheme who are desperately trying to claw back through restitution their assets, and he has assets. It seems to me that this would be a significant impediment to pursuing those until after, the 12 life terms or whatever he's serving.
Mr. Chair, the 90-day period before collections is not on parity with the 180-day period before the interest begins accruing. And the people who ask me to carry this bill believe that setting up a system that can confuse people about when they need to set a payment plans before a penalty is a reasonable thing to ask for, to try to make this on the same
And Mr. Chair,
time frame.
just so I'm not being totally unfair to the patron, I've got no problem with this with respect to many people.
Sure.
And I appreciate what you're trying to do, but I think that my concern is that this covers a lot of people we ought to be pursuing.
And Mr. Chair,
immediately.
if Senator Obenshain has an amendment, no?
Mr. Chairman?
Yeah, Senator Obenshain or Senator
It's
Norman?
McDougal, but
McDougal.
I'm going to move to strike out restitution, because I think we're talking about fines and cost, that there's probably universal agreement given the 180 days, but restitution, there is a victim that's out that, and they might be equally as indigent as the person that was charged, and they might need it more. And I think the example Senator Obenshain just gave, if a person has lost all their assets and a defendant still has those assets, but you can't go after them till after they're released from prison, then we're re-victimizing the victim. So I'm gonna move to take out restitution.
So which line?
79.
79. Strike the word or restitution, is that right? It could be fines, costs, forfeitures, penalties, but not restitution, correct? Is that right, Senator McDougal? Is that correct? Okay, been moved and seconded. Okay, go ahead, speak. Let's hear what she has to say.
Thank you, Mr. Chair and members of the committee. My name is Teresa Hepler. I'm an attorney with the Legal Aid Justice Center. Specifically to restitution, so what's going on right now with collections and what this bill is trying to address is actually make it easier for people to pay their court debt. We've heard from a lot of people who are recently released that them being required to pay their court debt as soon as they get out is basically impossible because they have to get housing, they have to get employment, and they don't have access to that. And yet this collections fee of 17% is assessed as soon as they basically get out because they've missed their payments because they haven't been able to work or find housing. With restitution, it's the same situation. It actually makes it less likely that they are going to be able to pay the restitution if they are accruing penalty fees, whereas if they just had a little bit of extra time to get back on their feet, they could actually make that restitution. But having restitution increase by that 17% just makes it harder for them to get it and makes it harder for victims to get that restitution. The typical person leaving prison is not someone who is wealthy. Most people who are leaving incarceration are indigent folks. So for those particular people, there are also civil remedies as well. I would say it's hard to navigate the collections situation right now because, as Senator Boysko said, interest is already accruing at 6 months. Collections is starting to accrue at 90 days, and so there's a disconnect, and that doesn't make any sense. Interest was changed in 2021 to give people the opportunity to get back on their feet. And as Senator Boysko says, this will actually probably save the state some money. The state pays more than that 17% offset to collect the money in the first place. So if you actually give people time to get back on their feet, they'll pay their bill. This makes it easier for them to pay those costs, and the state will not be incurring more money or paying more money. Thank you.
Okay, we got a motion before us to delete or restitution on line 79. All in favor of the motion, say aye. All opposed, no?
No.
No. All right, let's call the roll. All in favor of the motion to delete or restitution, vote aye. All opposed, vote no.
Ayes 8, no 7.
No 7. The bill, the motion passes. Okay, now we have a bill that's been amended, or substitute's been amended. Any discussion?
If anyone on Zoom would like to speak on this bill, we have a speaker on Zoom, Mr. Chairman.
Okay, speak. Go ahead.
Francis, once you get the notification to promote panelists, please unmute and give your testimony.
Sir?
Francis, you may unmute and give your testimony.
Go ahead.
Thank you, Chairman and committee members, and thank you, Senator Boysko, for carrying this bill. I just wanted to say that I was in favor of the bill. Now I kind of don't support it so much because I don't think that restitution should be removed. We want people to come back into society and be able to be successful. And this is doing more harm than good. Maybe you got, because I'm not an attorney, but maybe there could be a different resolution, like if you have X amount of money, then you don't qualify for the extension or something like that. Just thank you.
Okay, thank you. Next.
Mr. Chairman, we have one more speaker on Zoom. Barbara, you may unmute and speak.
Okay, go ahead.
Barbara, you may unmute and give your testimony now. Okay, never mind.
Okay, now we have a man in front of us. Go ahead.
Good morning, co-chairs, members of the committee. Dominique Martin, New Virginia Majority. We're also in support of the bill. Like it's been stated, the main point of this bill is to give people the opportunity to get themselves established, handle their most basic needs, to get them in stable situations so that they can, in fact, pay their fines and fees. And so we hope you support the bill. Thank you.
Okay, you ready? Is there a motion to report the bill?
So moved.
It's been moved and seconded to report the substitute as amended and re-refer to finance. All in favor of the motion, vote aye. All opposed, no.
Ayes 14, noes 1.
14-1, the bill is reported and re-referred. Okay, Senator Boysko?
Thank you. The next bill is 1282.
Okay.
Mr. Chair and members of the committee, SB 1282 is a bill that would provide uniformity across the Commonwealth for any person to repay or all or parts of the imposed fines and court costs by earning credits through community service for work while incarcerated in the Department of Corrections, prisons, or in a local or regional jail. And my understanding is that in 2020, Senator Obenshain opened this as a permissive opportunity for incarcerated individuals, and this would make it more consistent throughout the Commonwealth. We found that many individuals who are trying to take advantage of this are being denied, and we are trying to create some consistency. For existing legislation to be equitable across the state, a request for community service hours to offset a court debt should be always granted if the requester meets the requirements under the law. Real people who are incarcerated across the Commonwealth have been deeply affected by not having their hours counted. And for those who are struggling to pay, as we just had this conversation a second ago, we want to create a clear process. You and I know that individuals who are incarcerated make between, I believe, 12 and 55 cents an hour. Allowing a community service program that would be applicable in every part of the Commonwealth would make positive sense.
Mr. Chair.
Okay, Senator Deeds.
Just the one question I've got, if they are earning 55 cents an hour and working in the laundry, they don't get that money anymore. It goes toward fine and costs. Is that right?
Right, that is correct, Mr. Chair. And so they got to do a lot of weeks of 55 cents an hour. So it's a
The lady behind you
negligible.
is disagreeing with you.
Okay. They still get paid the 55 cents, but the difference goes to the offset.
Explain the difference.
So, hello, Mr. Deeds, and Chair. Maisie Osteen from the Legal Aid Justice Center. Each court would use their community service rate and they would subtract. This is what a bunch of courts across the Commonwealth are already doing. They take their community service rate, they less the minimal amount that the individual is getting paid, and then they use the difference to offset the court debt.
Okay, Senator Norman.
Just, I'm a little confused, and I apologize. Would the prisoner get a credit towards that amount? And maybe it was a misspeak, or is there actually the amount that he would earn be paid?
The individual would be paid that 55 cents. They would be paid the amount that VEC, the enterprise, commercial enterprise, they would get that amount. But the difference would just go to their court debt. They would not be paid that amount. That would just go to offset their court debt.
Mr. Chair?
At the community service rate that the court is already using.
Yeah, Senator Obenshain.
So that difference, like $14 an hour, who is paying that to the clerk? So where is that money actually coming from?
It would be, the court would be, there is no actual money changing hands. And they're currently already doing this in lots of courts, and under the program that your bill actually instituted, people are getting paid that de minimis number, and that's what courts across the Commonwealth are already doing.
Yeah,
it's the work and the labor that individuals are already doing on behalf of the Commonwealth that would be credited against their debt.
Okay, next, anybody have any questions? All right. Yeah, Senator Boysko, want to wrap it up, or anybody else want to speak for the bill?
If anyone on Zoom would like to speak to the bill, please
come on
raise your
up.
hand electronically.
Anybody that's here, come up real quickly.
Hello again, Dominic Martin, New Virginia Majority, and we support the bill for the reasons already stated.
Okay, thank you. Next.
I would like to say something in support of it too. We've been in touch with a number of people behind the wall, and currently the way that it's being applied, two bunkmates can be working the same job, they can be doing the same work, they can submit the same hours on the same form, and they can have completely different outcomes based on the court that they're in and what somebody's considering under this law. So trying to make it more consistent and applied consistently across the state.
Okay, next person.
Morning, Mr. Chairman, members of the committee. Jerry Fitz with the Virginia Department of Corrections. We do not have a position on the bill, but if we were available for any technical questions, should there be any more technical questions.
Thank you. Anybody on Zoom?
Yes, we have a few speakers on Zoom. Francis, you may unmute and speak, and Barbara, you will go next.
Thank you, Chairman and Senators. I'm going to just echo the comments that were mentioned before me and let you know that I support this bill and that it's necessary. And if it is your will, then it will be your will. Thank you.
Okay, thank you. Anybody else want to speak?
Mr. Chairman?
Yeah, Senator Obenchain.
Just very briefly, I want to point out, since I've been invoked in this, I did not create this funny money. This fictional repayment amount is created in this bill. It was not created in my legislation. My legislation would have required the payment of that application at 50 cents per hour. This is new language in lines 74 through 79. So I just want to clarify that.
Okay.
I wouldn't have any problem with applying that 50 cents per hour or whatever the actual payment rate is to the payment of costs, but this just,
Okay.
I mean,
All right,
nobody's paying it.
Okay, thanks. Anybody else want to speak? In
Mr.
favor of
Chairman, we
the
had
bill?
one more speaker on Zoom.
All right, very quickly.
Barbara, you may unmute and speak now.
Yes, Mr. Chair, Richard Walker, Bridging the Gap in Virginia. I've been a designated community service organization for individuals after or upon release or locally to do community service to reduce there. So I am very much in support of Senator Boysko's bill.
Okay, is that Barbara Adams? Okay, next person. Anybody else?
There are no more speakers on Zoom, Mr.
Okay,
Chairman.
Senator Boysko, you want to wrap it up, or shall we go ahead and vote? Senator Boysko? You'd like to, Senator Boysko, would you like to wrap it up? Or is there a motion? Is there a motion?
Move to report.
Okay, it's been moved. Is there a second?
Second.
Moves and seconded that the bill be reported. Since bill
Mr. Chair, it's gotta go to finance.
1281 and re-referred
Refer
to
to
finance.
finance.
Senate Bill 1281, all in favor of the motion to report and re-refer to finance, Senate Bill 1282. Vote aye or vote, or if you don't like it, vote no.
Thank you.
Senator Stewart, first Senator Stein. Ayes 9, no 6.
Thank you.
9 to 6.
Thank you,
Okay.
Mr. Chair.
Yeah, thank
My
you.
last bill of the day, we heard the testimony last week, and we ran out of time. It is SB 1156. It is the bill to close the loophole in Virginia and to better protect victims of domestic violence by clearly defining and penalizing suffocation versus strangling. As a reminder, I presented the bill as a substitute, and the committee accepted the substitute and heard my statement, had many stakeholders and advocates who traveled to testify. Nate Green is here for available for questions. 39 other states have adopted a similar policy. This will save the lives of primarily the women and children who are victims in these circumstances. And
Is there a motion to adopt the substitute?
we already did.
Okay.
Mr. Chair?
Yeah, Charles, I have an amendment.
Mr. Chairman, Mr. Chairman.
Yeah, go ahead.
If I recall correctly, that Mr. Benjamin was giving us some comments about the language differences between what's in subsection A and B in reference to bodily injury. If he could maybe refresh our recollection of what he was articulating then, would appreciate it.
Mr. Chairman, subsection A, the strangulation aspect, requires as an element that there be a wounding or a bodily injury. There is no such requirement with the new subsection B.
So, Mr. Chair, I believe your amendment would add in after person on line 15 resulting in the wounding or bodily injury of such person.
To amend the substitute.
Mr. Chair, could I address that?
Yeah, go ahead. No.
So many of the people on this panel oppose waterboarding, where there is no physical evidence that you have been tortured. This is the same concept. A person who is repeatedly has a pillow put over their face and then released, and a pillow put over their face and released, is treated with there is no physical evidence. However, that person has been terrorized and damaged. If you add this amendment, you will be leaving those folks out, and there will be no way to prosecute the perpetrator. I ask you on behalf of the babies and the little children who are being sexually abused and the domestic violence victims who are repeatedly being terrorized and by their partners not to put this amendment on.
I disagree. I think you need to have some evidence of some kind of injury. It doesn't have to be much. You have to have something.
Thank you, Mr. Chairman. I would just say that there are plenty of times in a case where you have to convince the court that something happened, that there is no bodily injury. I would ask you to hold on to the way the bill is written, the substitute, and not pass this amendment.
I understand what people are saying, but, you know, even in murder, you got to show a body, a dead body. So anyway, anyway, I have an amendment to add the language, because I think you need to show something. The language is to knowingly is to in the wounding or bodily injury.
Mr. Chairman?
Yeah, Senator Obenchain?
Can I ask what the Commonwealth's attorneys think of this proposed amendment?
Thank you, Mr. Chairman. Nathan Green, Commonwealth's attorney for the City of Williamsburg, James City County, here speaking on behalf of the Virginia Association of Commonwealth Attorneys. I do thank and respect Senator Boysko and her passionate advocacy for the bill as is. This amendment would make it more difficult. It would narrow the individuals. It is still better than the current law, and we can work with this amendment. Again, I share Senator Boysko's passions for those individuals that are simply terrorized but not injured. This would require there to be some injury. It is something we could work with. Again, not as good as the original would be my opinion, but definitely an amendment that we can work with.
Okay. I have an amendment. Has it been seconded? Second. All right. All in favor of the amendment to the substitute, vote aye. Say aye. Aye. All opposed, no.
No.
Show it. The ayes have it. Okay. Okay. There's a motion to adopt the substitute as amended.
Move to report.
Yeah, okay. Report is the motion to report
And
the
refer.
substitute as amended.
Has to go to finance.
And re-refer to finance. All in favor of the motion, vote aye. All opposed, no.
Peterson.
Senator Serval?
Thank you.
Ayes 15, no zero.
Thank you, Mr. Chair.
Okay, thank you. Okay, the next one is, where are we? Next bill is McDougal. Do you have a bill? Yeah, Senator Lucas. Do you have a bill?
Senator Lucas's bill has gone by for the day.
Okay, Senator Lucas' bill, Senate Bill 1256 has gone by for the day. So Senator McDougal, 896, racketeering.
Mr. Chairman, this was the one that I mentioned to the committee should probably be taken up with Senator Stewart's bill. We looked at the problem that we're hearing from many jurisdictions that with the larcenies, there are organized groups of individuals that are going around stealing. Sometimes that amount is less than $1,000, but in aggregate, it turns out to be more. So this would make it in the racketeering section, any person who directs or organizes the larceny in aggregate of $10,000 would be guilty of racketeering to try to go after those groups that are doing it in an organized manner. I think Senator Stewart takes it at a different approach. I don't think they're exclusive of each other. You could do both approaches, but this was the way that we came up to try to attack that situation.
Yeah. Okay, Senator Stewart says they're not in conflict. Senator McDougal, is there anybody who would like to speak for the bill?
If you want them to, they can, but otherwise I think it's pretty straightforward.
It is, Mr. Chair.
Yeah, Senator.
It is pretty straightforward. You just add petty larceny to the list of offenses included in the definition of racketeering. Is that right?
And, Mr. Chairman, it's still aggregate has to be 10,000.
Right.
So you could have multiple petty larcenies to get to that level.
Okay.
You would have to have multiple.
Anybody who would like to speak for or against the bill?
If anyone on Zoom would like to speak on this bill, please raise your hand electronically. There are no speakers on Zoom, Mr. Chairman.
All right, it's been moved and seconded to report and re-refer Senate Bill 896 to finance. All in favor of the motion, vote aye. All opposed, no.
Ayes 11, noes 4.
As 11, noes 4, the bill is reported and re-referred to finance. Senator McDougal, you have 1207, crimes by gangs. Okay, go ahead.
Thank you, Mr. Chairman. Mr. Chairman, this is, it references the gang statute. And what we did was in looking at it, we came up with a definition. Do you have a, substitute? We have a substitute. Mr. Chairman, I was getting ready to talk about substitute, but you don't have it.
I move we adopt the substitute.
It's been moved and seconded to adopt the substitute. All in favor say aye. Aye. All opposed, no. Motion carries.
Mr. Chairman, instead of taking it the way we did, what we did was the way the bill was originally done. All we did with this was reference back the violent felony offenses that are included in 16-1-253-2, which is just list them out. So this includes all felonies that are violent can be predicate for gang offenses.
How do you define violent?
Mr. Chairman, using the existing code section, that was already determined. So we didn't change. Originally, there was changes to what was included. In looking back at it and hearing feedback, what we decided to do was take the existing code section where this body's already determined what those violent felony offenses are and just reference those.
I see.
Did I explain it right, Charles?
Yeah, I see it. Okay, thanks.
So the substitute is much more straightforward and I think cleans it up substantially.
Okay, any discussion? Any questions?
Mr. Chairman.
Yeah, Senator Senator
Surville. Thank you, Mr. Chairman. Yeah, I'm still not clear exactly what we're doing. Can you give me some examples of crimes that were formerly not included that will be included going forward?
Mr. Chairman, I don't have the specific list of what was not included going forward, but what is included going forward are all those in 17-1-805, which list out, and I can read them all to you if you want. It's the violent felony statute. So there was a lot of different directions. We decided violent felonies were already defined in the code, and so we just referenced that section.
Mr. Chairman.
Yeah, Senator Surville.
So, and I understand the gang crime is a concern, but beyond the generalized concern about gang crime, what problem are we trying to address with this amendment?
Mr. Chairman, there are a number of situations, whereas the committee is aware that gangs are very creative, and this lets all violent felony offenses be predicates in using that. In my neck of the woods, it's not as prevalent as in some other parts of the state. So certainly if you want to hear from some people that prosecute gang crimes, they're happy to come forward and talk to you about them.
Okay. Anybody who would like to speak in favor of the bill?
If anyone on Zoom would like to speak in favor of this bill, please raise your hand electronically.
Senate Bill 1159, no, I mean 1207.
Good morning, Senator Edwards. My name is Anton Bell. I am the Commonwealth Attorney for the City of Hampton, and I represent VACA, Virginia Association of Commonwealth Attorneys, and we are in support of this bill. As you have seen, many gangs have become very creative in how they are going forth in the pursuits of their criminal activity. And so what has normally been traditionally violent offenses have now gone more so towards fraud-type crimes. And COVID was a very good example that revealed the creativity of a lot of our gangs. Many of them use PPE loans and things of that nature to be able to pursue their criminal intent and their enterprise. And so because of the creativity nature of our gangs and how they're ever evolving, we're asking this committee to support this particular bill and pass this bill.
Mr. Chair.
Yeah, Senator Morrissey.
Question for the Commonwealth Attorney, Mr. Bell.
Yes, sir.
Good morning, sir.
Good morning.
From Hampton.
Yes, sir.
Remember a basketball player by the name of Allen Iverson?
I do.
Yeah.
Went to Georgetown, went to play for Philadelphia. Greatest player not to ever win an NBA championship. Do you remember the situation with Allen Iverson in the bowling alley?
I do.
Allen Iverson was either 18, just made 18, or was just under 18, and there was a brawl that prosecutors in Hampton referred to as a mob. Okay, and he was prosecuted under that, and he went and he was given a lengthy penitentiary sentence.
That's correct.
Prior to Governor Wilder intervening, getting him out of jail and sent on to Georgetown. This bill, and they would capture Allen Iverson, wouldn't it?
I'm not sure about that, Senator. And the reason I say that is because there have been prosecutors such as myself and others who have come back afterwards and said Allen Iverson should not have been prosecuted in the way in which he was prosecuted.
Stop right there then, please, okay? And I'm going to let you answer. Look at the language on here. Any person, and tell me if this doesn't describe what happened to Allen Iverson. Any person who actively participates in or is a member of a criminal street gang, and there was a mob that you folks described as a gang, who knowingly and willfully participates in any predicate criminal act committed for the benefit or the direction of an association, shall be guilty of a Class 3 felony. You are capturing an individual whom we wouldn't want to put in there and subjecting him to decades in prison.
Well, Senator Morrissey, if you recall, the Virginia State Police now has given us a more defined definition of what a gang is. Allen Iverson, in that particular situation, would not fall into that category. So prior to the Virginia Virginia State Police coming up with those definitions, then probably you would have had that situation. But now, because of current guidelines, I don't think you will have that situation. And because it is now currently being defined by different protocols and statute, I believe that Allen Iverson would not be in that situation. And like I said, there are plenty of prosecutors, including myself, who would have said on the record that Allen Iverson absolutely should not have been prosecuted under that particular definition. So that is prior to me. I can't change what happened, predates me. But what I can speak to now is we have gangs who have been defined by the Virginia State Police to be a gang, and they are now doing things that are more creative than just your shooting and your killing. They are doing things that concern fraud. They're doing things like prostitution. They're doing things that goes well beyond what we typically would have defined as a gang activity. And we are missing those individuals, and they are creating havoc in our city. Right now, Hampton has had 6 homicides to date. We have to stop this. And if we don't stop this, we're going to continue to see bodies in the street. And that is the bottom line. We're trying to stop the violence, and we're trying to stop it in new and creative ways. Thank you.
Senator Morrissey, are you through with your question?
Final comment. A gang is either a legitimate blood crip gang, or it is a group of people who the prosecutors and police describe and determine to be a gang. That's the problem.
Well, again, Senator Morrissey, you and I will have to disagree on that. And the reason we'll have to disagree on that because you are, based upon your definition, you're saying that the police and the prosecution can just take a regular street, a group of individuals and just say, you're a gang. That is not how it works. There are guidelines that goes into what is defining a gang. And so you can't just take a group of individuals. They have to meet the criteria. And if they don't meet the criteria, they cannot be categorized as a gang. That has actually kept us from being able to prosecute certain individuals in the past. So it doesn't work that easily.
All right, thank you, Mr. Chair.
Thank you. Are there additional questions? Are there additional people that want to speak to this?
Thank you
bill?
very much.
Thank you,
If
sir.
anyone on Zoom would like to speak to this bill, please raise your hand electronically. There are no speakers on Zoom, Mr. Chairman.
Senator McDougal, on line 57, you increased the mandatory minimum from 2 years to 5 years. Is that your intent?
Mr. Chairman, probably was, but if it means that that if I can get it out of the committee by taking that out, then I'm happy to take it out. So,
Thank you,
fairly
sir.
practical.
Mr. Chairman, repeat that again. Which part are you taking out?
Well, I asked him if
I've got so many
on line
substitutes. I'm trying
57, it takes the mandatory minimum period of incarceration from 2 years to 5 years.
If that,
I asked him if that was his intent.
Okay.
Mr. Chairman, it is more important to have the items in than to deal with that. So I think you heard from Commonwealth Attorney that the issues arising now are gangs are doing things like trafficking in individuals and selling child porn. And those are the things that we're trying to get at more so than the mandatory minimums. Because if they convicted of doing that, I'm confident that judges will be sentencing them accordingly.
Okay, is that your wrap-up, or do you want?
That's,
Okay.
I think it's pretty straightforward as far as that.
The bill is before the committee. Motion to report, a second, is there a substitute motion?
Substitute motion. Motion to PBI.
No. That amendment has not been done. It's been the most, primary motion is to report and re-refer to finance. It's been seconded. The secondary motion is PBI, and that's been seconded. We'll go to the secondary motion first. So a green vote is a vote to PBI. Please open the roll.
Ayes 6, noes 9.
Ayes 6, noes 9. The bill is not PBI'd, so we're going to the primary motion. The motion is to report and refer to finance. A green vote is a vote to report. Please open the roll.
Ayes 11, noes 4.
Ayes 11, noes 4. Senator Morse, you have.
Thank
two
you,
bills.
Mr. Chairman, members of the committee.
917 and 1486, I think, are your two bills. Is that correct, Senator Morrissey?
Yes, sir. Yes, Mr. Chair. Can we
Okay.
take up?
917
oh,
is a bill we've seen before. We saw it last year, I think. I think this bill passed out of this committee last year. Is that correct? 917 reinstates parole.
Thank you, Mr. Chair. You're correct. Senate Bill 917 repeals the abolition of parole. Parole was abolished in 1995 under Governor George Allen's Truth in Sentencing. Due to this abolition, thousands of incarcerated individuals have been stuck in DOC serving excessive sentences.
I think we understand the bill
Got it.
because we saw it last year. Are there people that feel compelled to speak to this bill?
If anyone on Zoom would like to speak on this bill, please raise your hand electronically.
Okay, Judge Dotson.
You can read from my notes.
Mr. Chairman, I'm Chad Dotson, the Chair of the Virginia Parole Board. The administration strongly opposes this bill.
Thank you, sir.
Mr. Chairman, Claire Saberry with Commonwealth Attorney Service, with the Virginia Association of Commonwealth Attorneys and the Commonwealth Attorney for Madison County. We oppose this bill. Thank you.
Thank you, ma'am.
Chairman and Board Willie Brown for RIHD. I'm in favor of this bill.
Okay, thank you, sir.
We have a couple speakers on Zoom, Mr. Chairman.
Zoom speakers fine.
Valerie, you may unmute and speak, and Barbara, you will go next.
Valerie Slater on behalf of Rise for Youth. We support this bill.
Okay, thank you, ma'am. Is there another speaker?
Barbara, you may unmute and speak.
Yeah, Richard Walker, Bridging the Gap in Virginia. And forgive me for Barbara Adams, but she's one of my workers that incorrectly put my information in. And I am very much in support of this legislation, as individuals were given exorbitant times of incarceration that at this point in time, there's no future for any type of parole. Okay. So we would like to bring parole back. Okay. And we're very much in support of this bill. Thank you.
Sir.
Thank you, Barbara.
Francis, you may unmute and speak.
Thank you, Chairman, and thank you, Senator Morsley, for bringing this forward. I support this legislation, and I have to say it's pretty heartbreaking to see that the parole board opposes it. I don't understand that.
Thank you, ma'am.
There are no more speakers on Zoom, Mr.
There are a couple of speakers
Chairman.
behind you, Senator Morsi. I want to give them about 10 seconds each, and then you can sum up.
Thank you, Mr. Chair.
Please just state your position. We understand the issues.
Okay, Ashley Moore, the Legal Aid Justice Center, in support of this bill.
Okay, thank you, ma'am.
Thank you.
Okay, Senator Morsi, you want to sum up?
I'll summarize. Mr. Chair, this bill doesn't allow a get out of jail free. Any defendant or incarcerated inmate still has to come before the parole board and show, 1, they're rehabilitated, 2, they're remorseful for the crime, and 3, that they have the ability, wherewithal, and desire to become a productive member of society. I had several examples of people that have been paroled. I'm not going to go through their particular circumstances, but there are numerous. What we have done in the last 3 years in the General Assembly, we've reinstated parole for fishback defendants, for geriatric release, and for juveniles who have served 20 years of their sentence. We have said as a General Assembly that there is merit and reason and logic for giving people a second chance. That's what this bill does. Let them re-enter society after being incarcerated for decades.
Okay, thank you.
Thank you.
Senator Obenshain.
Mr. Chairman, let me just say, Joe and I clearly have a different view of this, and I respect his view and opinion. I was not here, but I was around in 1993 when parole was abolished. And I remember that folks were getting out of prison for first-degree murders after an average of something like 7 years. 7 years. We had a liberal and lenient parole system which deceived jurors. And jurors were, and I actually served on a jury back in 1980, I think in 1984. And the jurors sat there thinking that these sentences we were talking about were real. And I understand we now have judge sentencing, but what you're going to see are inflated sentences. Truth in sentencing has worked. Violent crime went down, and I just don't think it's provident to repeal this.
Senator Obenshain, I think under this bill, the truth in sentencing provisions that we passed in '94 would remain the law. This bill simply says that people are eligible for parole again.
I understand.
Mr. Chair.
Senator Peterson.
And I apologize. This part I was not here in the 90s other than as an intern, but if we reinstated parole, what would be the limits? For example, if someone committed first-degree homicide or someone committed, would they have to serve at least 30%, 50%, 70%? Maybe I have to make my apologies to Mr. Benjamin, because actually I do need his help here.
Senator Peterson, as I recall, the last parole chair, or one of the last ones, said it was 25%. Is that correct? Senator
Benjamin.
Mr. Benjamin.
Mr. Chair, there were categories, and back in the day, in the late 80s, 90s, when I was Commonwealth attorney, if you were convicted of first-degree murder, you had to serve 12 years. If it was a double murder, it was 15 years. The rule of thumb at that time was that you would serve 1/6 of your sentence, 1/6, before you were eligible. That's the rule of thumb. And I'm not saying we go back to that, Senator Peterson. What I am saying is that there will be rules and regulations and a formula that would give them an opportunity, I see it, after serving perhaps decades, to show, look at me. I've been incarcerated for 30 years. I've towed the line. Will you not consider me for a second chance?
Okay, thank you. Senator, Mr. Benjamin.
One answer is, just as Senator Morrissey has explained, there are formulas, but a more realistic answer is that the parole board has always turned down parole even when somebody became eligible for parole, the classic reason being because of the seriousness and nature of their offense. And so you have folks who are still serving a life sentence who are eligible for parole and have served 40 or more years and will continue to be turned down. That's always been the catch-all for the parole board.
Okay, thank you.
Thank you.
If
Under
people want
Adrian
to,
Bennett?
if you want the bill to be reported, it's got to go to finance. So the committee operates by motion.
Move to PBI.
Primary motion is PBI, and there's been a second. Is there another motion?
Substitute motion, report and refer to finance.
Okay, there's substitute motion to report and re-refer to finance. Is there a second? There's a second to that motion. Secondary motion takes precedence. All in favor of reporting and re-referring to finance, vote green.
Ayes 7, noes 8.
Ayes 7, noes 8. The secondary motion is to PBI. A green vote is a vote to PBI. Please open the roll.
Ayes 8, noes 7.
Okay, the bill is PBI. Senator Morrissey, you've got another bill.
I do. Mr. Chair, Senate Bill 1486, please, I would move the substitute. It's a very short bill.
It's a simple bill. It takes the rate for substitute judges.
No, it was changed, Mr. Chair, but you were correct. What it does, it fulfills my intent that any justice, judge, member of the SCC, or member of the Virginia Workers' Compensation Commission who's retired and comes back to serve, that their daily rate goes from $200 to $500. It does not touch the substitute judges. The genesis of this bill were some circuit court judges who were retired were coming back and said to me, listen, we're serving all day on, say, a securities matter, jury trial. The bill, we're getting paid $200 a day. So that's it.
Okay.
Mr. Chairman.
Substitutes before you, do we have a motion to adopt substitute first?
So moved.
Motion to adopt and substitute. All in favor, say aye.
Aye.
Okay, Senator McDougal.
Mr. Chairman, I put in a budget amendment that I think goes to the same amount that Senator Morrissey did, because we do hear this complaint a lot, that retired judges, they were wanting to serve, willing to do it, but it actually costs them more money to go and spend an entire day doing it than any other thing that they could do. It's that $200 is less than most attorneys charge for a single hour. So I think if we want to make sure we have good judges sitting, we need to increase the
Does everybody understand the bill? Are there people in the audience that are compelled to speak to this bill?
If anyone on Zoom would like to speak to this bill, please raise your hand electronically. There are no speakers on Zoom, Mr.
There's been a motion
Chairman.
to report and re-refer to finance. Is there a second? Okay, all in favor of reporting and re-referring to finance, vote green. Okay, thank you, Senator Morrissey.
Thank you.
Senator Norman's next.
Ayes 15, no 0.
He's not here. Well, I've got Senator Peterson's got Senator Peterson, Senator Stewart's got some witnesses. Do you have? You go first. Okay, so you have 3 bills, Senator Stewart? Okay.
Thank you, Mr. Chairman. Senate Bill 1396 is the first bill, and there's a substitute if y'all could distribute that.
They were not on. Okay, 1396 is a bill that's come up in a couple of other conversations this morning.
There's a substitute, Mr. Chairman.
Okay.
I'd move the substitute. If someone would
Okay,
second
we've
that.
got a motion and a second. Is there a second? Second. Okay, all in favor of adopting the substitute, say aye. The substitutes before you. This was the bill that we discussed a little bit in relation to. It includes 1596, which we've already made that motion earlier, and it's similar to 896 as well. So it's come up in a couple of conversations, but if you'd like to describe the bill.
Mr. Chairman, I'll describe it briefly, and then hopefully I can tell you real quick. The first thing it does is takes away that mandatory minimum of 30 days that Senator Serval was concerned about. What was the other difference, Charles, that I can't remember now?
So, Mr. Chair, the substitute gets rid of the third offense, petty larceny, as a felony. It also deleted the property crime section from the bill. And the last change is on lines 55 to 59. It essentially combined some of the elements in the introduced version. So now a person needs to conspire or act in concert with another person to be guilty of this offense.
Right. Thank you, Charles. So, Mr. Chairman, now what is left of the bill is it creates a definition of organized retail crime in the code, and it establishes that crime, makes it a Class 3 felony. You have to commit simple larceny in an aggregate over $1,000 in 90 days. It also adds petty larceny as a predicate criminal act and racketeering statute. This comes as a result, and it creates a fund as well. It comes as a result of the work group, which was the bipartisan work group, which was put together by Senator Barker and Delegate Byron in order to address the organized retail theft that we have been seeing in Virginia and nationwide. That is a summary of the bill. I know you all have looked at it. We tried to do the substitute to address the concerns that we were aware of, and hopefully it does that, and there probably are folks who'd like to speak to
Senator
Mr.
Stewart, do you think it affects the corrections impact of about $15 million for the state and $3 million for local?
I suspect it does.
Okay, you think the substitute affects that?
I do.
Okay. Are there any questions for
Yeah, no,
Senator
I'm sure
Stewart?
it affects it. Yes, sir.
Are there any questions? Are there people that?
Mr. Chairman,
Senator Serval.
I just want to make sure council can confirm something for me, because we saw a version of this before it got introduced. I just want to make sure that the way it's written right now.
Substitute you're speaking of?
Yeah, well, even before the bill was introduced, we saw some drafts. I want to make sure that what we have before us right now would not allow a situation where an individual, not acting with anybody else, just acting on their own, commits 3 larcenies and gets themselves somehow into this punishment scheme.
Mr. Chair, to answer Senator Serval's question, yes, the substitute does require any person who conspires or acts in concert with another person to commit simple larceny. So a single individual cannot be guilty of this offense solely on his own. He must act with somebody else, either by conspiring or acting in concert with them.
Okay, further question, Mr. Chairman?
And that language
Senator
starts on
Serval.
line 455, Scott.
Yeah, so that makes me feel better. The other thing I would just say, does council, I mean, I see this as a Class 3 felony, and I'm not aware, I mean, arson's a Class 4, I think. I'm not aware of many property crimes that go as high as Class 3 felonies, where there's not like a bodily injury. Are there any other property crimes that go as high as a Class 3 felony?
So, Mr. Chair, I'll say not that I'm aware of. I know grand larceny is 5 to 20, and as a Class 3 felony, I believe the stat max on Class 3 felonies are 20. So I believe it was designed to essentially match up with the max on grand larceny.
Got it. Okay, thank you.
But, Mr. Chairman, if I may quickly.
Senator Saslow's got a question.
What's the prison time of a Class 3 felony, Steve? 5 to 20. All right.
Okay.
Let's suppose, I mean, I basically support what you're trying to do, but here's one potential problem. Let's suppose the total value of what they steal is $1,500. They acted in concert with each other. So for $1,500, 2 people would go to jail. That would be about 30 times 2, 60,000 times 5. So for about, say, $1,500, you're asking the taxpayers to shell out $300,000 to house them. Hell, we can send them to Harvard for less than that.
May I respond?
Senator Stewart, yeah.
Mr. Chairman, Senator Seslaw is right in some respects. That's not actually the object of the bill, but actually that crime now cost the taxpayers about $700,000 for every $1 billion of loss. And
For every million.
billion, I think, is what it is.
I understand that.
And we're shifting that cost to the taxpayers constantly of all the goods that are being stolen. This is not to address somebody stealing $1,500. This is to address organized crime. That's the whole point of it, because these are bands of people that are manipulated by others, stealing this merchandise. I think there are people who want to speak, Mr. Chairman.
Are there people that want to speak in favor of this legislation?
If anyone on Zoom would like to speak in favor, please raise your hand electronically.
You know how to do this, Bill.
Yeah, well, I'll just wait. Morning, Mr. Chairman.
Keep it short, please, Senator.
I'm not gonna belabor the point. Virginia State Police Association, we're in support of the bill. We were on the study throughout the year. We've seen how much that the retail businesses are losing through this process, and it's a growing crime around us, and it's moving into Virginia rapidly, and we support the bill.
Okay, thank you, sir. Next.
Mr. Chairman, members of the committee, Jody Roth on behalf of Virginia Retail Federation. We support the bill. We appreciate all the work that was done with the AG's office, Senator Barker, Delegate Byron, and Senator Stewart for carrying this. Thank you.
Thank you, ma'am. Next.
Mr. Chairman, members of the committee, Lindsay Whitten with Amazon. We appreciated the opportunity to serve on the ORC working group, and we support this legislation. Thank you.
Thank you. Next.
Elizabeth Holmes with the Virginia Sheriff's Association, and we support this bill.
Thank you, ma'am. Next.
Mr. Chairman, Paul Spidell with CVS Health. We participated in the work group, strongly support the bill. Thank you.
Thank you, sir. Next.
Mr. Chair, members of the committee, Ken Hutchison on behalf of Walmart and its 45,000 associates in Virginia. We support the bill. Thank you.
Thank you. Yes. Next.
Michael Newman, Commonwealth Attorney, City of Danville, here for our Virginia Association Commonwealth Attorneys. We support the bill.
Okay, thank you, sir. Okay, are there people on Zoom that want to speak in favor of the legislation?
There are no speakers on Zoom,
Okay.
Mr. Chairman.
Are there people that would like to speak against this legislation?
If anyone on Zoom would like to speak in opposition, please raise your hand. There are no speakers on Zoom, Mr. Chairman.
Okay, was there an amendment to the bill?
Mr. Chairman, I neglected to answer part of Senator Seslaw's question. This actually costs the state about $80 million a year in lost tax revenue. And I didn't get that in trying to ask that question is.
Okay, a motion to report is going to require referral to finance.
Mr. Chairman, I have one more quick question.
Senator Survey.
Maybe council can answer this for me. So, I understand the gang activity and the organized, whatever they are, smash and grab gangs, and I get that's a problem. I just want to make sure we're not picking up somebody with like a drug problem who's stealing and putting stuff on eBay. So if somebody were to like steal something, like say like a vacuum cleaner or something, put that on eBay, would that meet the terms of a conspiracy? I don't think it would, but I just want to.
Conspiracy requires 2 or more people.
Yeah, no, Mr. Chairman. Mr. Chair, you would need to do it with another person. So if a person just went and stole a vacuum from Walmart and then tried to, as the bill may say, fence it on eBay, he still needs to act with somebody else. The conspiring isn't the transaction of the sale. It would be required that the conspiring would have to be to commit the theft.
Okay, all right.
That conspires or acts in concert. Language, okay. Anything else from the committee? We operate by motion. A motion to report and a second. Are there other motions? And send to finance. Okay, a vote green is a vote to report and re-refer to finance.
Ayes 14, noes 1.
Ayes 14, noes 1. Okay, you got your quota.
Do you want me to continue or let somebody else go?
You said you'd be quick, and I'm going to respect you to be quick with those two if you want to, and then Senator Norman, Senator Peterson.
Okay. I don't have any witnesses for these, Mr. Chairman.
Okay.
Mr. Chairman, Senate Bill 1103, and obviously we're all trying to figure out ways to address these shootings that we're seeing and mass shootings, and what this does is it defines violence, a first, second-degree murder, voluntary manslaughter under Article 18.2-30, mob-related felonies under 18.2-38, kidnapping or abduction, any malicious, felonious assault or malicious bodily wounding, robbery, etc., arson, and it makes that an additional felony to use a weapon in that regard in a business, a place of worship, a courthouse, or a hospital. I think I explained that as expeditiously as possible, Mr. Chairman. And obviously, this is a policy issue, but I ought not have to be afraid to go to work for fear of somebody pulling out a gun and shooting
The
somebody.
main question I had about this legislation was on line 17, place of employment. In the Zoom world we live in today where some people are working at home, could home be the place of employment?
Mr. Chairman, I would defer to counsel, but I think it could be if you had other people there. If I work from my home, I guess you could construe it, but I don't think that's the way.
I don't see where this requires other people to be there, does it?
No, but I was just thinking of the
If I'm just doing a Zoom, I'm
rational way
zooming
to
from my home, and
interpret
somebody
it.
comes in and kills me there.
Mr. Chair.
Senator Peterson.
Question for the patron. Senator Stewart, one of the things I noticed that we're saying that if you use a weapon in a workplace incident, it's a Class 3 felony, and it's a separate and distinct offense which shall run consecutively. So let's say you shoot somebody or you brandish or what have you at a workplace and you get, well, do whatever, and so you have that original crime that you're prosecuted and convicted of, and then you have the Class 3, which is 5 to 20. So, I mean, you could be stacking some pretty heavy sentences on people for may or may not be a serious incident. Now, I get it, a weapon's involved, but it also could, that weapon, I mean, maybe it's in their car, maybe it's on their, I don't know if it's within their dominion and control. It just seems like this could lead to some very disproportionate sentences for what may not be life-threatening situations.
Mr. Chairman, as I said, it is a policy decision to make. I was struck by something Senator Serval said earlier in the day on another bill where he said punishments don't necessarily deter crime. And that is not what I've found in 30 years of practice in law.
Listen to Serval, that's a mistake.
That's the mistake, right. And that's what this is all about. And having represented folks for nearly 30 years, it is exactly this sort of thing that deters crime because they understand that if you do certain things, there are severe punishments for it, and that might not always be the case when somebody intends on killing a bunch of people and shooting themselves. I get it. But it may deter some, and it may save some people's lives, and it is a harsh result.
Senator Morrison.
But sometimes that's what you have to do to stop this.
Senator Stewart, let's assume arguendo that punishment deters crime. Tell me this. If an individual shoots up a workplace and there's 20 people in there and that person injures, sadly, several people and is charged with 5 counts of aggravated malicious wounding, that penalty range is 20 to life. Doesn't have to kill him, just aggravated malicious wounding. 3 more are killed, they get life. That punishment won't deter him, but if we add this consecutive punishment, all of a sudden the light goes on, and I'm not being cheeky, and they say, oh, I could get an additional punishment so I won't commit the crime. That's what you're saying. This additional stacking of the punishment would deter.
Mr. Chairman, I think I just said it probably wouldn't work in that case. There are cases where people intend to go in and shoot a bunch of people and potentially shoot themselves or something. Not going to work in that case. But there are situations where it may deter, and we've got to use whatever tools we can to try to stop these things because they are becoming too often. And this is just one other way to do it.
Okay.
Final question, Mr. Chair.
Senator Morrissey.
Senator Stewart, why do we have, if there's a crime that or offense that's committed, pay the penalty for that? Why do we have to stack it and make one criminal act come under 2 or more code sections in Virginia? Why do we have to have multiple punishments for one horrific offense?
Mr. Chairman, because it gives us one other tool. That's the point of the bill.
Okay, thank you, Senator. Are there people in the audience who would like to speak in favor of this bill?
If anyone on Zoom would like to speak in favor, please raise your hand electronically. There are no speakers on Zoom.
Is there anyone that would like to speak against this bill?
If anyone on Zoom would like to speak in opposition, please raise your hand electronically. There are no speakers on Zoom.
The committee operates on motion.
Move to report, and Senator Stanley seconds.
Okay, this will have to go to finance as well. It's been
Yes,
moved
sir.
and seconded. Are there substitute motions?
Substitute motion.
Senator Morrissey.
Motion to PBI.
Second.
Substitute motion to PBI has been seconded. Substitute motion gets primary consideration. All in favor of PBI, vote green.
Ayes 9, no 6.
Okay, the bill, you've got one more bill, 1383.
Yes, Mr. Chairman. And Mr. Chairman, this is a different approach. So there is one common thread in every one of these mass shootings that we have seen, and that is that somebody knows somebody's getting ready to do something, and they don't know what to do about it. And I have thought long and hard about this study, done a lot of research. This just creates a hotline where they can call. And you would hope that if they call this hotline through the state police, through good old-fashioned police work, and hopefully they would have some mental health training, that investigator would, they could talk to that person and maybe intercede and stop something from happening. Doesn't give up anybody's civil liberties or constitutional rights, anything like that. It just, I'm hoping that through that phone call, we can get to that person and talk to them before they snap. And that is all this bill does. But it could be a very useful tool.
Okay,
Mr. Chair.
have you, Senator Morrissey?
Love the spirit of the bill, Senator Stewart. Right now, people are indoctrinated into, if they think a crime is being committed or is about to be committed, they dial 911. Is it, and 911, I've visited a few call centers. It's really impressive. Would 911 not be the better resource to then direct that person for mental health, or do you envisage a different scenario going on here?
Mr. Chairman, what I have read and studied about these is that coworkers knew that their coworker was going to do something and they just didn't know how to deal with it. And it wasn't an imminent sort of thing to call 911. It wasn't, my coworker Joe has a gun and he's getting ready to go shoot somebody, but it was more the sort of thing, he wasn't acting right, something wasn't right, we knew something was wrong, was afraid he was going to do something. So this just gives, I don't think this substitutes 911, but this is something else that people can use when it's not quite that emergency, I guess is what I would say.
Yeah, Mr. Chair.
Senator McClellan.
Didn't we just create, I can't remember if it's 811 or 988 or what it is, but didn't we just create and have take effect a different call center and line to address mental health related issues?
Mr. Chairman, I don't know, but I'm happy to amend this along the way if that's the case, if you all like the idea.
Yeah, Mr. Chair, I mean, I do.
Senator McClellan, yeah.
So we created that separate line for the specific purpose that when you had someone in crisis, you wanted to make sure you had a mental health professional be the first responder and not police because of, all of the escalation that can occur. I think rather than creating a new line and a new center, we might somehow want to incorporate the duties you want in your bill with that new center. So I don't know, does this have to go to finance?
I don't think does this bill have to go to finance?
Yes, Mr. Chair.
Okay, so somewhere between here and finance, you
And
might
Mr.
wanna
Chairman, let me
double check on
respond. That my idea was that you would have someone with both investigatory skills and mental health skills.
Right.
I think you need that unique combination to be able to know how to ask people questions and same time talk them down from doing something.
But before this bill leaves here, you've got to figure out what you do with the information what do you do with this information? What happens if a person is charged with a crime as a result of this?
I
mean,
I don't know that it would
happens in
be
the
any
discovery
different.
process?
I don't know that it would be any different from any other. This is just an avenue to try to intercede. I'm not sure I understand your question, Mr. Chairman.
Well,
how it would be any different than anything else?
What in the discovery process in a criminal trial, wouldn't this information be relevant? I mean, wouldn't it be admissible or discoverable?
If the information was taken down and there were other things done, potentially, yes. But the idea here is you're just alerting in order to try to help someone before they commit a criminal act, I guess is what I'm saying. I don't know if it creates, I guess what I'm saying is it doesn't create anything new in terms of what you're suggesting. I'm thinking as I'm talking. I don't see where it creates anything new.
Have you talked with the Fusion Center about this?
I've had some discussions with the state police, and I anticipate that we're going to have amendments along the way.
Okay.
That's what I anticipate, Mr. Chairman. I want to work with them, not against them.
Okay. Are there people in the audience who would like to speak in favor of this bill?
If anyone on Zoom would like to speak in favor of the bill, please raise your hand electronically. We have a speaker on Zoom, Mr. Chairman.
Please keep it quick because we've got a bunch of bills yet to go.
Francis, you may unmute and give your testimony.
Thank you, Chairman and Senators. I think that this is a great bill. The other number that they were talking about is 988. I just think that in this part of the bill, there should be an extra clause to make ordinary Virginians who don't have a reason to follow what you guys are doing there even know that these services exist. And I think that's the problem. We pass these new things, but people don't know that the services are out there. Thank you.
Thank you. Yes, ma'am.
There are no more speakers on Zoom, Mr.
Okay, are there
Chairman.
people that have a contrary view? Are there people opposed to the legislation that wish to speak?
If anyone on Zoom would like to speak in opposition, please raise your hand now. There are no speakers on Zoom,
Okay,
Mr.
the
Chairman.
bill is before the committee. It has to go to finance.
Move to report and refer to finance. Stanley seconds.
Okay. A motion to report and refer to finance, that's your green vote. Open the roll, please.
Ayes 15, no zero.
Okay, we're back to Senator Normand. And that's Senate Bill 1353.
Mr. Chairman, ladies and gentlemen of the committee, I'm a pragmatist, so I want to make a verbal amendment that is not particularly challenging. On page 1, on lines 16 and 17, I would respectfully move to delete the new language that enhances the felony there. Sitting on finance once or twice, the fiscal impact on it makes it unrealistic at this point in
So
time.
you're talking about that increases the mandatory minimum from 3 to 5 years and 5 to 10 years?
On page 1, yes.
That's
yes,
on lines
Well,
21.
it starts on 17. It actually is punishable as a Class 4 felony.
Okay.
So it would basically just restore it back to what the current
So
language.
you're talking about the substitute. I apologize. There is a substitute. Do I have a motion to adopt the substitute?
Am I working off the
Is there a
substitute?
second? You were working on a substitute, I was looking at what was in the book. I
Well-
apologize. All in favor of adopting the substitute, please say aye. Okay, the substitute's before you, and Senator Norman has already moved to amend the substitute to delete the language on page 7, or language on line 16 and 17 that increases the penalty to a class 4 felony.
It would just restore it to the existing language.
Okay, but you're leaving the 5 to 10 years for second or subsequent offense?
I'm going to page 2 in just a minute.
Okay. Well, that's on line 19 of the first page.
Yes, sir. It goes back to 5. All of those changes would go back to the
Okay,
current statutory
so
language.
basically, you would be eliminating all the new language in paragraph, or in 18.2-53.1?
Yes, sir.
Okay. You understand that? Is there a second on that amendment?
Mr. Chairman, Servo.
Senator Servo.
I think the motion would be to strike lines 10 through 21 from the bill, right?
I think so, yes.
All right, I'll second that motion or make it.
Okay. All in favor of that amendment, say aye. Aye. Okay. Any opposed? Okay, so now we're doing with 308.1.
The other change in the bill that I'm not offering an amendment to is over on page 2, which deals on line 41, which does enhance the punishment from a class 6 to a class 5 and enhances the minimum mandatory. And if you read subsection C, it's pretty straightforward because it's dealing with child care and elementary, middle, and high schools. And it does include a minimum mandatory with enhancing to a class 5 felony.
Okay, I think we understand the bill. Are there people here that would like to speak in favor of the bill?
I didn't ask anyone to comment.
If anyone on Zoom would like to speak in favor of the bill, please raise your hand electronically. There are no speakers
Are
on
there
Zoom,
those
Mr.
that would like
Chairman.
to speak against the bill?
If anyone on Zoom would like to speak in opposition, please raise your hand electronically. We have the speaker, Mr. Chairman.
Okay, well, we've got a person in person. Let's let them speak first. And I'd ask you to keep it brief.
Hello again, Mr. Chair, members of the committee. Dominic Martin, New Virginia Majority, and we would just oppose the bill on the expansion of mandatory minimums. We hope we don't expand them anymore. Just so on that reason, we oppose.
Okay, thank you, sir. And there's a person online.
Thank you, Chairman, and thank you, Senators. I oppose all mandatory minimums, so therefore I oppose this bill along with my 1,400 members. Thank you.
Thank you, ma'am.
Just quickly, Rob Hogan-Class, Justice Forward, Virginia. We oppose mandatory minimums and we oppose the expansion of them.
Okay, we've got another person too.
Monica Hutchinson with Rise for Youth, and we oppose this bill. Thank you.
Okay, thank you, ma'am. Okay. So I think do we understand the bill? Do you want to sum up, Senator?
It is perplexing to me in this atmosphere where we're having so many firearms and crimes being committed on school grounds that people oppose it. I understand you don't like minimum mandatories, but as you know, we're having a lot of instances of it. And of course, I favor minimum mandatories in general, which I respect some of you don't, but it is perplexing to me how people can stand up and say they're opposing that in child care centers and schools.
Okay, thank you, sir. The committee operates by motion. Got a motion to report in a second. Are there substitute motions? Yes, Senator Morsi.
Substitute motion.
Senator Morsi.
Substitute motion to PBI.
Okay, is there a there's a second to that motion. The secondary motion takes precedence. A green vote is votes PBI. Please open the roll.
Ayes 8, no 6, abstentions 1.
Okay, ayes 8, no 6. Senator Peterson has a bill.
Thank you, Mr. Chair.
Thank you. Thank you.
Mr. Chair, members of the committee, this is, well,
I think I got the wrong folder. It's Senate Bill 1504.
Okay. I've handled a couple of these cases, and I tell you, I've never handled one where the state police were in favor of taking anybody off the registry, and I just wondered why you wanted to set up a separate process within the state.
Well, you know what, I'm gonna turn this over, and I gotta move quickly, I have a meeting upstairs, but Mary DeVoy's here, and I think, if I can just summarize, basically, when someone has been convicted, they've been registered, they've served their time, the question then becomes, do we give them a method to disenroll? And right now, basically involves filing a petition with the circuit court, and Mary can give the details on that. And that's both time-consuming and expensive. And what we're looking for is some type of way that we can allow someone to, in this case, petition the state police to just get their name off the roll.
Yeah, I get all that, you know, but I've filed these before on behalf of people, and I've never found one where the state police were in agreement with the person coming off, and I wondered why you'd set up another process within the Department of State Police.
Do you want to speak with them before
No.
I tell you what happened? So,
I have to be upstairs. Can I leave my proxy with Senator Servell?
Have you done that?
Louise, can someone do that for me? I got to run up to.
thank you, it's okay, thank you. Thank you very much. I contacted 15 attorneys this summer to file a petition for removal for someone that should have been able to be removed 10 years into their registration, but it became 15 years because of a bill that was sponsored in this committee and that passed and had no start date and was retroactively applied. Out of the 15 attorneys I contacted this summer, only 3 would file the petition. One wanted $10,000, one wanted $5,000, and one who contacted me 4 months late said $2,500. Excuse me, the $5,000 was the one that contacted me months later. I don't have $10,000. So this is for someone who has a single offense that is a tier 1 or a tier 2, one offense. Our petition, the offense was not even a registrable offense, but the assistant Commonwealth attorney at the time and the judge said register. So we thought we had 10 years, and it turned into 15 with the retroactive change in the law. No failures to register, not one, and that includes the extra 5 years that have been done, and yet we still have to petition the court. We didn't have $10,000, so we filed the petition pro se. And guess what? Our petition is not being opposed by the Commonwealth. So we waited for a hearing to be scheduled because that's what we had been told would be next. We waited 6 weeks for a hearing to only find out last week that actually we need to have a sketch order. So now we are going to have to pay someone to do a sketch order, even though we did a perfect petition. So we are now on day number 89 today since we filed a pro se petition for someone with a single offense, 0 failures to register, and they did an extra 5 years for an offense that didn't require registration. This should not take this much time and money to do. And this bill is crafted for a single offense.
I get it. There's no, if the state police deny your request, you might.
So they wouldn't deny the request because if this became law and it was a single offense and they've done their time, they pay for a criminal background check to go with the form that is submitted to the Virginia State Police. And as long as the criminal background check doesn't have any additional convictions and they have done their 15 years in one day or they have done their 25 years in one day, they would be removed. They have done everything that was asked of them.
So they're never going to turn one down.
Mr. Chairman, it's automatic as I read it.
Yes.
Okay.
If they meet the requirements.
Okay, are there any
Correct.
questions? Senator Morrissey.
This issue that you're describing is far more complicated than this bill, although I agree with the bill, okay?
Mm-hmm.
Here's the problem. The SOR started as a non-public registry that then became a public registry. And then you used to be able to get off of it after 10 years or 15 years, and the goal line continues to move. So, Mr. Chairman, somebody that could get off of it after 10 years, then it became 15, 20, then life. That's the problem. And the courts right now, the courts of record, really have no choice. They're sending it up to the Court of Appeals. And we're going to get a decision down soon about this. But I understand the problem. And it puts that brand, that what's that scarlet letter on somebody's forehead forever and ever. And they originally were told you will be able to get off of it, but the legislature, years after they committed the crime, moved the goal line on them. I think that this may have some merit, and that's why I'm going to get the support, but you need to address the question, the specific question, why will the police, state police, support something like this when they seemed to be completely reticent to allow somebody off the SOR?
So about 20% of our registry are the tier 1s and the tier 2s, and not all of them would qualify for the automatic removal. They would still have to petition the court to do that, but it would save about $2 million a year if those people who have done their 15 and 25 years with 0 new convictions and only 1 failure to register, if not 0 failures to register, to release them because they have met what the state asked them to do. The state asked them to not commit a new crime and to faithfully register, and they have done that. So if we're just going to continue to keep them on the registry, then everyone should just be a tier 3 lifer, and every restriction and regulation that right now is divided into 3 tiers should just apply to everybody.
People, their minds have already been set, those that have a vote. We could hear a lot of
Senator
folks.
Obenshain's got something.
Yeah, just a quick question.
Sure.
And Mary, I get what you're after, and I understand the difficulty, and that there are many who probably deserve to have their names removed. But my question is about the person who doesn't deserve it, the person that the state police has information about, has concerns about, has open investigations on at the 15-year point. That person, 15-year and 1 day, that person would be automatically removed, and the state police would have, I mean, it's not enough,
If they have any additional convictions, they would not.
No conviction, but the state police has information that indicates this person should not come off because there are, 5 open investigations. We're just not ready to bring the charges yet. That person winds up coming off automatically, correct?
At this point it does, but if you want to add an amendment for any open investigations and it gets bumped to the court, I'm fine with that. I am trying to carve this out for a very, very small group that has done everything, that has no new convictions, who cannot afford $10,000 to get the attorney to do this, and we are going to keep them on our registry for the rest of their life. So we are monitoring them and re-registering them every year. That costs money. A trooper has to go to their house twice a year.
Yeah. I don't know quite how to fix that, but
I could talk to Senator Peterson and we could try for an amendment if that would make everyone happy.
Well, I'll tell you what, this bill does not have to go to finance. Why don't we take it back to the next meeting and
Okay.
try to work on an amendment
Okay.
that addresses Senator Obenshain's concern?
That sounds
I
good.
think
Will
that
someone notify Senator Peterson of that, or do I need to do that since he's not here?
Mr. Chair, I can work with Senator Peterson.
Okay, do you have something that needs to be said, or?
I just wanted to add one point, which is the money to hire an attorney.
Who are you?
My name is Zachary Jesse. I'm the president of Safe for Virginia. We deal with a lot of folks on the sex offender registry.
Okay.
Folks on the registry often have huge hurdles to employment that makes hiring an attorney even more onerous. And this process doesn't let new people get off. It really just expedites the way for someone who has shown that they are not a threat to society to get off. So this is just an opportunity for them to expedite and make easier a process that, by and large, a judge will hopefully grant because they haven't gotten in trouble for 15 or 25 years respectively. Thank you.
Okay. Well, and that bill will go battle next week, and we'll work on a substitute. Senator Servell's bill does not have to go to finance. Senator Edwards is here. I've got 3 bills that I think have to go to finance, and I'd like to take them up if I could.
Okay, yeah.
Okay, so first one is Senate Bill 1291. It's an anti-swatting bill. And here's the problem. I had a middle school child in Charlottesville. There's a substitute for the bill. Second. All in favor of the substitute, say aye. Aye. Okay, Senator Edwards is chairing now.
Yeah.
I had a middle school child in Charlottesville that came to me and basically was crying in my office. She was in a closet with a bunch of other students. The school had been called. There was an active shooter there, but the active shooter wasn't there. I had another situation in Charlottesville where 10 and 11-year-old children, after the school had been called, were basically shoved away with other kids and teachers, and they were calling their parents, saying goodbye on their cell phones. 10 and 11-year-old children. So the whole idea of this bill is to disincentivizes that sort of conduct. 20 schools and 18 school districts in Virginia were swatted on September 19th. At least 14 additional incidents took place last year at schools, community centers, and private homes. 182 schools were swatted across the United States. So Washington, Kentucky, Texas, California, New Jersey have statewide swatting laws. All 5 include felony components. What the substitute does that's different from the bill is it adds the Virginia State Police to the organizations that may receive restitution from swatting. It eliminates the new definition of emergency personnel and references the term as defined elsewhere in the code. Paragraphs C and D adds language that the bodily injury or death is as a direct and proximate result of the false emergency communication, and it eliminates the work group. There are people here, I think, that want to speak to the bill.
If anyone on Zoom would like to speak to this bill, please raise your hand electronically now.
All right, Mr. Chairman, members of the committee, thank you so much. We really appreciate working with the patron on this bill to combat swatting. I'm going to turn it over to our lieutenant in Arlington, who has worked really closely with us. I'm representing Arlington County here today, and we just really thank the patron. It's really important that we keep our kids safe in schools and that they're not having any trauma related to these fake communications that are sent to 911. Thank you.
Mr. Chairman, members of the committee, my name is Matt Martin. I'm with the Arlington County Police Department here in support of Senate Bill 1291. Achieved several important objectives, but there's one I'd like to highlight with you. It closes a gap in current Virginia law. We had an incident at a high school about a year ago where somebody called the school directly, and of course the school staff member who received the call then called 911. When our detectives were investigating that case, they realized that indirect swatting, calling another person and causing them to call 911 is not currently illegal under Virginia law, and there was no charge they could have brought. So that means if somebody calls a shopping mall, a movie theater, a grocery store, even a private residence, and gives that person false information about a violent ongoing crime, and that person calls 911, that's currently not a crime in Virginia. So for that reason, we support Senate Bill 1291 and ask you to do the same. Thank you.
Thank you, Mr. Chair.
Go ahead.
Good morning, Kathy Bircher on behalf of Roanoke City Public Schools. We support this legislation, and aside from the disruption to the day, you can only imagine the emotional toll and the traumatic toll it takes not only on the students there, the staff there, and the families there, and for those reasons, we support the bill.
Elizabeth Holmes from the Virginia Sheriff's Association, and we support the bill.
Mr. Chair, members of the committee, Nicole Whitman on behalf of the Attorney General's office, we support the bill.
Mr. Chairman.
We have a speaker on Zoom, Mr. Chairman.
Senator McDougal.
Mr. Chairman, you can take the Zoom first. I have a question about some of the language.
Alan, you may unmute and speak now. Alan, you may unmute and give your testimony now. Okay, never mind. There are no more speakers, Mr. Chairman.
Mr. Chairman.
Yeah, Senator McDougal.
Just right now, what is the penalty for currently engaging in this activity if you call EMS directly? Is the penalty structure lined up the same? I don't have any problem with making it a criminal offense. I get a little concerned when we talk about the results of the activity change the nature of the offense. So if we're criminalizing the offense, and I'm 100% in agreement with that. I don't necessarily love the pieces where we're saying the different outcomes result in different criminal penalties. Should be the penalty, the action itself results in the criminal penalty.
So Senator McDougal, your problem specifically is with paragraph D.
Well, Mr. Chairman, I think it would be C and D, but I want to know if that's what we do currently, if there's a report made directly to EMS or directly to communications, what's the penalty for that? Does it follow the same structure?
If you make a false report to the
It's a Class 1 misdemeanor.
is there any elevation if there's some kind of bodily injury?
There is not, Mr. Chairman.
And Mr. Chair, it's the same for calling EMS too, with that, or firefighters.
Class 1 misdemeanor?
Class 1.
Mr. Chairman, I just think it ought to parallel that. It shouldn't be an enhanced penalty because I think it should be a penalty if you call the school, but not an enhanced penalty if you call the school as opposed to EMS. I think the same should be the same.
Mr. Chairman, I think the reason for the enhanced penalty is that, that when you're calling a rescue squad or calling 911, you basically inconvenience some people, but you don't inconvenience a whole lot of people. And when you're calling a school, you could have a mass of kids that are all of a sudden upset, and
Mr. Chair.
you could cause a great deal of difficulty.
To that point, and I guess this might be a question, if someone calls a threat to 911 rather than calling directly to the school, is the ultimate result the same, that the school will go into lockdown and some sort of threat drill?
Yes, Mr. Chairman, Senator McClellan, the outcome is going to be the same at the school if we get reliable information that there's an act of violence going on. Just to address Senator McDougal's question directly, the enhanced penalty is not based on whether you call directly or indirectly. It's based on whether there's an injury or death. And the reason that's so important is because swatting is often done not just as a prank, but with the intent to hurt somebody, with the intent to send a SWAT team to a place and hoping that something bad happens. And 2 people have been killed nationwide through swatting calls. And the risk is very great to the public, not just from the response of the SWAT team, but also the officers running code to the event.
Yeah.
So that's why there's the enhanced penalties for the injury or death.
Senator Morrissey. Wait, I'm not finished.
No, I'm sorry, Senator McClellan.
And I wanted to speak to that because not only is that putting lives at risk, but I have seen firsthand the trauma and anxiety going through an active shooter drill or event puts on the kids, particularly, if they know it's a drill, and sometimes the teachers will kind of signal to the kids that have anxiety, like, this is a drill. But when it's not a drill, and the people that they usually look to for some indication that they're going to be fine are also terrified, that adds another level of trauma to those kids. So I'm glad that somebody mentioned that, but I just wanted to emphasize that.
Mr. Chair.
Yeah, Senator Morrissey.
Nobody needs to be convinced that swatting is dangerous. Senator McCollum referred to the trauma, but when you have a score or more of police officers responding, running, carrying assault rifles to try to end this act of violence, there's certainly the potential for danger or violence. But this is Senator McDougal's question, and I'd like an answer to it. If I call 911 myself and say there's an act of violence at such and such middle school, and the SWAT team responds, that right now is a Class 1 misdemeanor for falsely reporting swatting, correct?
Correct.
However, if I tell somebody else about it and they call 911, then that same behavior now becomes a Class 5 or 6 felony.
That's not correct.
Okay, thank you.
So the way it works is whether you call directly or call indirectly, if no one is injured or killed, it's a Class 1 misdemeanor, the same as the current statute for making a false report to police. The enhanced penalties, the felonies only kick in if there is serious injury as defined elsewhere in the code or death.
Follow-up question and last question. If I call in right now and there, as a result of that, there is serious injury, is it a class 5 or 6, or does it remain a class 1 misdemeanor?
If it's just an injury, there's.
Serious injury.
Serious injury, it's still just a misdemeanor.
That's my point.
Mr. Chairman.
Yeah, Senator Morrison, Senator
Serval.
Serval.
Thank you, Mr. Chairman. And, you know, Arlington County brought this bill to me, I don't know, 2 months, 3 months, maybe longer ago. And all the concerns that are being raised right now are some of the things that I raised with them at the time. And two of them are, right now, if you call EMS, you call 911, the call's recorded, right? And you have a recording of what was said. In this situation, you call a school, there's zero recording. And, you know, one of the things I deal with as an attorney all the time is what one person hears is often very different than what one person says or intended. And then you get to court and trying to figure out what those words are can be a real problem. And this also sort of enhances the penalty based on what the reaction is of some person who didn't commit the crime. And there could be lots of different reasons why the person could react that way, or perhaps after the investigation occurs, could alter when they have to repeat what was said that caused them to do it. They reframe what was said, and now all of a sudden you're dealing with a felony circumstance instead of a misdemeanor. And we had a similar bill last year that Senator Sproul was carrying, which was similar to this, and the code differentiated between oral threats and written threats because oral threats are, impossible to corroborate often, whereas written threats are in writing, and so it was easier to justify the felony for something in writing versus something that was made orally, which was a misdemeanor in that circumstance. And I sort of felt like the same thing applied here, is that, elevating this to felony conduct on an oral statement that's not recorded, that is also dependent on the reaction of some third party, could create all kinds of scenarios where stuff gets, jacked up into felonies because somebody, makes a mistake or whatever. And so those are the kinds of concerns I had, which made me very uncomfortable with this whole concept.
Thank you. Yeah, okay. Is there a motion or any discussion further? All right, Senator moves to report and refer to finance. It's been seconded. All in favor of the motion to report and refer to finance, vote aye.
Ayes 13, noes 2.
Okay, 13 to 2.
Mr. Chair, I've got one more bill that has to go to finance, and that's Senate Bill 1532. And I think there's a substitute for that bill.
Okay, 1532.
Second.
It's been moved and seconded. All in favor of the substitute, vote aye. Say aye. All opposed, no. Motion carries.
Okay, 1532 in substitute form is a series of changes to our protective order statutes that was brought to me by the Virginia Poverty Law Center. It accomplishes two things. First, the bill provides a mechanism to ensure that a protective order does not lapse if there's a gap between the expiration of the protective order and the hearing on the motion to extend. Despite someone's best efforts to seek out an extension, if the hearing does not occur before the existing order expires, they will not be able to get an extension. The substitute permits the court, when a motion to extend is received, provided it is received before the order expires, to issue an ex parte protective order that will remain in place until the extension hearing is held. Second, the bill allows the petitioner to ask for a continuance if they can show by clear and convincing evidence that a continuance is necessary to meet the ends of justice. The significant differences between the introduced version and the substitute version, the first one is it eliminates language awarding monetary relief that was on lines 159 and 160 of the introduced version. The second is the introduced version allowed the court to extend the protective order. As I mentioned already, the substitute allows for the issuance of an ex parte protective order in certain instances. The third is that the introduced version allowed the petitioner to ask for a continuance for good cause. The substitute has a higher bar for the continuance. Shashila Barkey is here, I think, just from the Poverty Law Center, can speak to the bill.
Okay.
Good morning, Senator Deeds, Mr. Chair, and members. I think Senator Deeds did a good job of explaining the bill. You all passed laws in 2010 allowing for a motion to extend, but if a person brings that written motion to extend before the protective order expires, but the protective order expires when that motion to extend hearing is held, they cannot ask for that motion. So this allows a PPO, which is a change from the original bill. The sub-language allows an ex parte PPO to be put in place for 15 days or until that motion to extend hearing is held. So that's one change. And then, did you have a question? The other change that Senator Deeds outlined is right now only respondents may ask for a continuance of the PPO, which makes sense, right? It's an ex parte order that has usually put them out of the home. This would allow for petitioners to ask for a continuance if they can show clear and convincing evidence that meets the needs of justice. One example I have is the petitioner gave birth to the party's baby the night before the protective order hearing. Nothing in the code now would have allowed that person to ask for a continuance.
Mr. Chairman.
Mr. Chairman.
Just
Senator McDougal.
couple questions that I guess immediately concerned me, and I'm trying to read the substitute that we just got. But this allows the written motion to extend without that the petitioner has been subject to family abuse. That's the whole point of the protective order. So why would we, maybe Charles, you can tell me why that language is there.
So, Mr. Chair, this, under the current provisions for protective orders, for a permanent protective order is granted, the original petitioner can extend that protective order without showing a new recent act. So this language is designed to just deal with when the ex parte PPO is entered for that gap coverage, that the petitioner doesn't need to show that there is a recent act. They still need to, they're still apprehensive, they're still scared, that's why they want to extend, but they don't have anything to show within those past 2 years that a new act occurs, because the code currently allows such extension for the final order without having to show a new act.
That's accurate.
Mr. Chairman, so.
Yeah, Senator McDougal.
Mr. Chairman, I guess that's where, and I'm just going through the substitute that we didn't get till right now. So with this, there's an emergency protective order that's entered based by either law enforcement officer because of an arrest or a petitioner files it. Then there's the request for the preliminary protective order, and there has to be some information in that. That could be ex parte, the filing of that. And then it's set for the permanent protective order within 14 days. And so this is talking about extending it past the 14 days.
This is talking, Mr. Chair, this is talking about after the permanent order has been granted. The 2 years are set to expire, and the petitioner wants to extend that permanent protective order. So if the permanent protective order expires after 2 years and person comes in on, day, 363 of right before the 2 year period and says, I want to have a hearing to extend that permanently protective order. They can't schedule a hearing before the 2 years expires. They extend it 2 weeks after. This is designed to give some gap coverage between that time. So after the end of the 2 years, you would ask for a ex parte preliminary protective order to do the gap coverage so that when the court has the hearing on the extension, there is some protection covered.
So, Mr. Chairman, if I'm extending on this line 13 and 14, hearing to extend a protective order at 16-1-279-1 is the
permanent
is
section.
The final permanent, okay.
Correct. And that's why it's without alleging the petitioner has been with a reasonable period of time subject to family abuse, because you don't need to make that showing when you're seeking the extension of the permanent order.
Mr. Chairman.
Yeah, Senator.
Surabel. So, Mr. Chairman, I'm less concerned about that piece as I am the piece of this that allows the petitioner to seek a continuance of the initial hearing. And just so we're clear, I mean, these protective orders we're not talking man v. woman, like, these are issued equally on both sides. I see them issued all the time in an effort to manipulate child custody cases. And you're talking about a man or woman being both not only thrown out of their house on an ex parte allegation, but you're also talking about denying them child custody, visitation, sometimes other things can be issued. And the reason you have it right now so only the respondent can seek the continuance is because it's an extraordinary remedy. And to then give a judge the ability to continue it for the petitioner when you're being denied in some ways a lot of constitutional rights on a short-term basis based on ex parte allegation, that gives me deep concern. And there's a reason it's currently set up that way. I understand there might have been one situation where somebody was pregnant and couldn't make the hearing. They could also go, I think, and probably swear out a new order in that circumstance if that were to happen. But that language, I guess it's on lines 89, 90, 91, and then it appears again, I think, a second time at 310, 11. That gives me deep concern, and I can't support the legislation with that in. So I just note that. I'd be happy to move to take that out if the bill otherwise might pass. I see other nodding heads, so I think other people agree with me. I don't know if that might help your bill, Mr. Chair.
May I respond to that question? So I do understand where you're coming from. I think the language that was changed with clear and convincing evidence to meet the ends of justice addresses that.
Yeah, Mr. Chairman, I don't agree.
Yeah.
Sorry, we'll never agree about that.
Mr. Chairman, what if you had a situation where somebody had COVID for 2 months and they said they couldn't get to court? That would be clear and convincing.
Right.
The judge still gets to have discretion about whether to order that extension and whether long COVID, et cetera, meets that definition.
Okay, any further questions? Anybody else want to speak for the bill?
Mr. Chairman, I move to strike that language from those two places, 89 to 91 and 310 and 11.
Yeah, okay, it's been moved. Is there a second? Second. It's been moved and second to strike the language indicated. All in favor of the motion, say aye. Aye. All opposed, no. Motion, no. One no. Okay.
Move to report and re-refer to finance.
It's been moved and seconded to report the bill as amended and re-refer to finance. All in favor of the motion, vote aye. All opposed, no.
Still couldn't say.
Ayes 13, noes 1, abstentions 1.
Mr. Chair, I've got one other bill on the docket, and I've been advised that has to go to finance too, and so I'd like to take that up if possible.
Okay, go ahead.
It's 1310, and we've got a substitute for that as well. The whole idea is to strengthen the existing protections for personal information of judicial officers online. I'd move the substitute.
Second. All in favor of the motion to adopt the substitute, say aye. Aye. All opposed, no. Motion carries.
Okay, this recommendation arises from a judicial council study of the security needs of judicial officers initially prompted by magistrates who issued arrest warrants for individuals charged in connection with the Unite the Right rally in Charlottesville in 2017. Magistrates' names were posted online along with a call of action for people to search for and share their personal information online, including residential addresses and work hours, along with threats of death and bodily harm. So that's what this bill was about. There were some concerns raised by the Press Association with respect to the substitute. I think that addresses the issue, but I want you to, the issue that was raised was about the requirement in the code that that the address be on a deed for the purposes, and be in the records for purposes of sending real estate tax tickets. And so we tried to modify this language somewhat. This is similar to laws that have been introduced and passed in 19 states. Those states all have laws addressing publication of personal information of judicial officers. My understanding is that there is legislation being considered in other states, and the federal government has enacted a new law that protects federal judges' personal information online, but doesn't protect that of state judicial officers.
Anybody want to speak against, favor of the bill or against the bill? This is a Judicial Council recommendation. Okay.
If anyone on Zoom would like to speak on this bill, please raise your hand electronically.
Go ahead.
Mr. Chairman, Alyssa Padden with the Office of the Executive Secretary. As Senator Deeds mentioned, this bill is a recommendation of Judicial Council after a study. We thank Senator Deeds for bringing this legislation, and we're happy to answer any questions.
Any questions?
Mr. Chairman.
Yeah, Senator Serval.
Thanks. I just want to make sure we're really clear what we're doing here, and I think this is a problem. It's a much bigger problem than this that requires a more comprehensive solution, but I just want to make sure I understand this. So for the public, I know there was some protests this year of U.S. Supreme Court justices, one of which lives in my neighborhood. And so if somebody were to say, let's go picket Justice X's house and put that on Facebook, they'd be able to be prosecuted as a Class 1 misdemeanor under this now, right?
That was a federal judge.
Yeah, and federal judges are included on line 18.
Okay.
That would now be a Class 1 misdemeanor, right? If you were to put
right?
that on Facebook or Twitter, we're going to meet at Justice so-and-so's house and picket.
Well, it does require the specific intent to harass or intimidate, I believe. So you would have to prove that specific intent. But yes, that is currently a Class 1 misdemeanor under current law.
No. Under this,
Any further discussion?
Under this, it would be a Class 6 felony.
okay.
Okay.
You're right.
Any further discussion? Anybody else want to speak briefly? I think the bill's in good shape.
Thank you, Mr. Chairman, members of the committee. Megan Ryan with the Coalition for Open Government, not the Press Association. And thank you. I do see that the substitute does address the issues that we had with the publication of on the internet of any database. I do still have some concerns with the indefinite nature of this bill, and that this bill is an automatic, that just simply by asking for it or demanding it, that it can be, rather than having a request based on the factors for the other people, which have a reasonable fear of harm, that sort of thing.
Any
Thank
further
you.
discussion?
There are no speakers on Zoom, Mr. Chairman.
I'll move the report and re-refer to finance.
It's been moved and seconded that the bill be reported and re-referred to finance. All in favor of the motion, vote aye. All opposed, no. Did you vote yes?
Ayes 15, no zero.
Okay, item 15, no zero. The motion carries.
Mr. Chairman.
Yeah, I have a bill.
Mr. Chairman.
Yeah, on my bill. Senator Deeds will take over.
Senator Serval, do you have something related to 1080? This bill, the last bill went to finance. And this is the last bill we're going to take up this morning. Senate Bill 1080 from Senator Edwards. And I think this is similar to a bill we saw last year that passed out of this committee, passed out of the Senate, and met another fate on the other side. Is there any change?
Yes,
this bill?
there are a couple of changes. First of all, one addition to the bill, which is Delegate Vivian Watts' bill last year in the House, and that is the following. It specifies that a delinquent child 11 years of age or older who has committed a delinquent act would not be prosecuted in juvenile and domestic relations court as delinquent. And then a person, and the reason is that a person under 11 years of age does not have mens rea.
So this thing does two things. It raises, allows a juvenile court to have jurisdiction until 21, and it says that a person under age 11 is not going to be charged, not going to be prosecuted for a crime.
That's right. And the reason for the underage 11 part, which is new, is, it wasn't my idea originally, but that children under 11 don't have mens rea, don't have mental intent.
And it might be interesting to know that the American Legislative Exchange Council agrees with this, and states such as Texas, Arkansas, Louisiana, Mississippi, and Utah, and Nebraska have a similar type of law.
So Senator Edwards, it's fair to say that you're carrying ALEC legislation this session.
Yeah, would you believe that? And also, the United Nations Convention on the Rights of the Child think it ought to be 14.
Okay.
And this is
Does
up to 10.
anyone have
through
any
10.
questions of Senator Edwards about this ALEC bill?
I'd also like to, that's the second part of the bill, so it's a very small part of it. I don't know if anybody wants to change that or not, but I want to speak for the fact that underage people between 18 and 21, according to science, do not have the judgment factors of somebody over up to 24. In fact, Harvard University, and by the way, this bill goes into effect 2025, not right away. And Harvard University has done studies on this, and the science shows that adolescents don't really mature in terms of their judgment until probably 24 or 25.
Mr. Chairman.
And this bill goes up
Senator
to
McDougal.
age 21. Yeah,
So, Senator Edwards, do you think that those individuals shouldn't be required to sign up for selective service and go into the military till they're 21?
That's a very good
consume
question.
alcohol, not be able to consume marijuana, not be able to drive because their judgment is not yet totally formed until they're 21?
We've already decided.
No contracts?
They can't, the contracts, a good question on contracts. The federal government says if you're under 21, cannot be held liable under a credit card. And also, you can't smoke, you can't buy alcohol until you're 21 years old. Now, you can drive at 16. In fact, Harvard has studied the fact that in Roanoke City, we also have a research institute doing the same kind of studies on this. And they're saying if you're 16, your cognitive faculties are pretty good. That's why teenagers are really good with computers and science and math. But when it comes to judgment, they're not so good. In fact, the judgment factors, you tend to be more peer-oriented, emotionally driven. And I'll give you two stories. If you were 18, 19, or 20, and your mother said, don't jump off the cliff, it's too dangerous, and your peers are jumping off the cliff, what would you do? You jump off the cliff. And I had some 19-year-olds in my office several years ago on a hazing situation, and they were forced to drink too much, run too much. It affected their health. It affected their grades. And so we had a claim against a certain fraternity. And they're 19. I looked at both of them, all of them, three of them. I said, what did you do this for? This is the dumbest thing in the world. They looked at me like, huh? I thought we had to. All of our friends were doing it. Our peers were doing it. This is how they think at that age. So the difference between judgment and cognitive skills.
Mr. Chairman?
Senator McDougal.
My 11-year-old has been with me on Friday and today, and her judgment is pretty good in a lot of things, and if it's not, she gets into trouble. And she knows that.
Well,
that's pretty clear. But, Mr. Chairman,
here's the thing.
I think when we're looking at this, this is impactful in a lot of ways. It's contracts. We've decided that you can't get married until you're 18. Are we changing that to 21? Or how do we do a system that puts a number of decision-making things that you can be reliable and responsible to in district court, and then a number of things that you cannot?
Here's the other thing. Not only is at a certain age, they're emotionally driven, they're peer-oriented, but the fact is the potential for rehabilitation is much better at this age. In fact, the juvenile courts are better at rehabilitating people. At that age, they're more prone to be rehabilitated. Their neuroscience has proven the behavior is better to be rehabbed at that age, and they're better, well-suited to learn from lessons of experience. In fact, it's rewards that make them better, not punishment. If they're better off, I'm talking about science. It has nothing to do with ideology.
Senator Morrissey.
Senator Edwards, I agree with the spirit of the bill. I'm going to support the bill. What surprised me, though, is that for the exact reasons that you stated, and you gave us a white paper on brains not being fully informed until mid-20s, why didn't your bill include something that prevented a child that was 14 or 15 from being tried as an adult if he or she committed a heinous crime. I really would have liked to have seen that in here.
Well, the prosecutor can move to transfer the case to circuit court.
I know
in
what
a
they
certain
can do.
case.
And I know
That
they
has
can
not
transfer
changed.
it.
That's a thorny issue that wasn't included in this bill, Senator Morrissey. I would say, somebody would say, get your own bill.
Well, I know, Mr. Chair, and I actually asked staff about it. I'm just curious, I'm just taking temperature. If staff, and I believe they can put in that provision in this bill, would that complicate matters for you? Would you be amenable to it if we could do it?
Well, it does say the prosecutor can transfer it to circuit court anyway.
It would make it less likely to pass.
Okay.
I mean,
Right.
here's the thing. The first part of Senator Edwards' bill was introduced in this committee last year. Senator Edwards passed
the Senate.
We passed the Senate, it died in House courts. The second part of Senator Edwards' bill was introduced by Delegate Watts last year, and it was tabled in House courts as well. So that would be adding another provision, 3 strikes.
I'd like
Delegate Kilgore said, get my own bill.
I'd like to continue. My history also proves what I'm saying. In ancient Rome, you had to be 25 to be a mature adult.
Are there other people that would like to speak to the bill?
And
If anyone on Zoom would like to speak to the bill, please raise your hand electronically.
Yeah, I'm not sure mines are going to be changed.
There were a bunch of people
Anybody
wanted to speak.
online? There
Yes,
are
we have
people online.
several.
And I'd ask you to be very quiet. Just tell us whether you're for or against the bill. And if give us your name and any group you represent.
We've got some people here.
Hello, my name is Ashley Moore, the Legal Aid Justice Center, and we are in support of this bill.
Okay, thank you, ma'am.
Okay.
Mr. Chairman, members of the committee, Jennifer Gilmore with the Office of the Executive Secretary, and for logistical reasons, the Committee of District Court Judges has recommended that we oppose this bill.
Okay, thank you, ma'am.
Good morning, Mr. Chair, members of the committee. My name is James Toohey from the Department of Juvenile Justice. We strongly oppose this bill. This bill, we believe, will
Well,
run.
thank you, sir. That's all you needed to say. Appreciate it.
Rob Hogan, Class Justice Forward, we support the bill.
Thank you, sir.
Tom Bell with the Commonwealth Attorneys. We oppose the bill because of the logistical problems.
Thank you, yes. Okay, and there are people online that want to speak.
James, you may unmute and speak, and Valerie, you will go next.
Just tell us who you are, whether you represent a group, and whether you're for or against the bill.
Thank you, Mr. Chairman. Yes, James Dold, representing Human Rights for Kids. We do support this bill because if a child is too young, believes in Santa Claus, they shouldn't be able to be prosecuted. Thank you.
I still believe in Santa Claus. Okay, are there others online?
Liz, you may unmute and speak, and Tyee, you will go next.
Thank you very much. Good morning. I'm Liz Barnard. I'm a pediatrician and researcher on youth justice. I'm a clinician in juvenile hall. I'm a member of the board of the National Commission of Correctional Healthcare, and I strongly support this bill, and I would be glad to provide more information. Thank you.
Are there others?
Tyee, you may unmute and speak.
Tyee Mallory, representing the Virginia NAACP. We support the bill.
Okay, thank you, ma'am.
There are no more speakers on
Okay, there's
Zoom.
one in person.
Yes, Monica Hutchinson for Rise for Youth, and we support this bill.
Okay, thank you, ma'am. Okay. Senator Edwards, do you have 2 seconds to wrap up?
Yeah, we used to have a law that said if you're in college, the universities and colleges were in loco parentis, in place of the parents. And that's when it was at 21. And as I mentioned, somebody mentioned pediatricians support the idea as well, and the Psychology Association.
Mr. Chairman, I have a motion.
Senator Morrissey's got it.
No, I want to know, what did the Aztecs do about this situation? Do you know?
Senator Stanley.
The Aztecs?
Yeah.
The Aztecs.
How did they handle this maturity
Senator
and maturity?
Morrissey's hat's got the floor. Senator Stanley's out of order. Please lock this guy up. Guards. He's out of order. He's out of order.
Mr.
Senator
Chairman, he's
Morrissey's
not
got-
21, so it's, you can't do that.
I'm still 16. It's about time this committee recognized Senator Morrissey's got the floor.
Mr. Chairman, I have a motion. While I would have loved to have heard more about the Roman Empire and the Incas, the Aztecs, and the Mayas, I do have a motion to report.
report and re-refer to finance.
This is all about signs.
Is
It's
there a
all about
second?
signs.
Okay, there's a second on the substitute motion. All in favor of reporting, re-referring to finance will vote green.
Ayes 9, no 6.
Okay, we've got one bill left on the agenda, and my understanding from Senator Servell is it can wait till Wednesday. So,
As long as, yeah, staff says it's not going to finance, then yeah.
so we're done. Do we need to hear it?